position as a principal in charge, my lord. So, my lord, and also, my lord, if permanent principal is appointed, then my whole appeal become infructuous.
My lord, may be taken up tomorrow then. Mr. Roy is appearing for respondent number
My lord,
11, who is indisposed.
My lord,
He's not
not
keeping
tomorrow,
up.
my lord. In next Monday, my lord, because we will be out of station tomorrow.
So you want it next Monday?
Yes, my lord.
Okay.
But my lord, status quo order may be passed.
Matter is not heard, my lord.
Matter has not been heard yet.
Yes, my lord.
How
Then,
will-
my lord, take
No, my lord. Then if they are expressing so urgency, matter will be taken up tomorrow then. My lord.
my lord, we cannot do tomorrow, my lord.
Then we'll list it on Monday.
Then, my lord,
How can we pass status quo order without hearing the party?
then, my lord, I want to argue tomorrow, my lord, on the matter.
Okay, on request made on behalf of Mr. P.K. Roy, London Council for respond number 11. Please again on. Tomorrow is what?
Fifth, yes. Deeply obliged.
Tomorrow.
Obliged. May it please your lordship, I beg to mention a writ appeal for listing, lordship. It is filed on 30/11/2023, lordship.
Okay, Monday, 11.
Lordship, next Wednesday, lordship.
Okay. 13.
Obliged.
May it please my lords, I beg to mention item 14. I seek adjournment for the day, my lord. My lord, what has happened is there is a sudden health issue of the conducting council, my lord. It was
What?
unexpected
For the appellant.
for the appellant, my lord. APDCL, item 1414. Sudden health issue, my lord.
Who's the council?
Mr. SP Sharma, standing
On
counsel for APDCL.
On request made on behalf of Mr. S. Sharma, let me counsel for the appellant. Then standing counsel APDC for the appellant. Release after 1 week. Yes.
Obliged.
Wait, please, your lordship.
Mm.
Lordship, I have filed a writ petition on Friday, lordship, regarding section 14 of the Surface Act, lordship.
Mm.
So this matter will be taken up. There is an urgency in this matter, lordship. Taken up today or tomorrow, lordship.
Day after tomorrow.
Lordship, actually, what has happened, lordship? The on 5th is the date for vacating the premises, lordship. So if I may pray, lordship, tomorrow, lordship. Highly obliged, lordship.
May it please your lordship, it is for listing of a writ appeal, lordship. We have filed it long back. There are 2 writ appeals pending. It may be listed any date next week, lordship. On Friday, lordship.
15th.
Obliged, lordship.
May it please your lordship, I beg to mention item numbers 18 to 22, your lordship.
Eighteen to
22, your lordship.
yes.
With the consent of all the parties, lordship, I pray the matter be adjourned for 2 weeks.
You are applying for
I'm appearing for the appellants in item number 18, 19, 20, and 22.
I am for the item 21. Okay. You are applying on behalf of
Of the appellants, your lordship.
who's your senior?
Mr. P. Mahanta, your lordship.
Okay, on request made on behalf of P. Mahanda, then the council to the appellant in WBC writ appeal number 363 of 2023. This is the matter.
In 2 weeks, your lordship.
2 weeks will be next year.
After a week, your lordship.
The matter after 1 week.
Your lordship, there's an interim. The interim may be extended.
Interim order facility to continue till the next September.
Much obliged, your lordship.
Item 1 for motion.
The last occasion, there was a direction to me to obtain inspection method regarding allotment of rooms in the.
Yes.
I have received the instruction. After following due procedure, prepare advertisement, local advertisement, and constituting the selection committee, the rooms has been allotted. That is the instruction method. But this instruction is in vernacular language method, in Assamese language.
Oh, it's in vernacular.
My vernacular.
Then you translate it and.
My lord, I may allow to file a short affidavit in the
Okay,
next.
you can file your affidavit. But Mr. G. Utin,
Yes, Lord.
can I conflict the petition? Mr. D. K. Shamal and
Additional.
additional senior governor. Appearing for respondents 3 and 4. How much time?
2 weeks, man.
It's allowed 2 weeks time to file affidavit. Let's again out. 18th.
January.
18th December.
December, man.
Obliged.
Okay.
Item 2.
May it please your lordship. Lordship, this subject matter of this PIL involved the issue of lordship leftover physical non-judicial stamp papers which are lying in the state unused. After the notification, lordship would be pleased to find at annexure to page 35. May I read the key points of that notification? Page 35.
Yes.
Yes, sale of physical non-judicial stamp papers from treasuries to be discontinued with effect from 1st July 2023. Physical stamp paper purchased before 30 June so by vendors and common people for ticket transaction to be allowed till 30 September. Non-judicial physical stamp papers to be discontinued with effect from 1st October 2000, except in the means social unforeseen cases, and in such cases use of physical stamp papers may be allowed by district registered with prior permission from the superintendent of stamps. Rule governing digital stamping, Assam digital stamp payment of duty by means of e-stamping rules to be notified. Existing stamp vendors with valid licenses will be rehabilitated by converting their establishment into citizen service centers for which 1 lakh will be provided. Now, here in this case, lordship, after this notification, the all physical stamp papers has been discontinued. Now, lordship, crores or more than 400 crores of stamp papers are lying within the state unused, and that has been duly purchased by paying the government revenue. Lordship, I'm taking at my contention, which I have pleaded at page 9, lordship, para number 9 of my petition. May kindly be. Lordship got it? Page 9, para 9. That the petitioner begs to state that as per the cabinet decision dated 15/6/2023 and to that effect by gazette notification dated 23/6/23 has already discontinued selling of physical non-judicial stamp papers from respective treasurers with effect from 1/7/2023 in exercise of provisions of clause 1 of the said notification, and from 1/7/2000, there is no such transaction of selling non-judicial stamp from any of the treasuries in the state of Assam, resulting in huge number of non-judicial stamp papers in different denomination of total value of more than 451.89 crores in 26 numbers of treasuries, out of which are near to 408.55 crores is of higher denomination from 100 to 25,000 are lying in 26 numbers of treasuries which are purchased by the state government.
Lordship, regarding the contentions raised in this PIL, Lordship, a similar natured case, writ petition 5572 of 2023. Lordship, all Assam Stamp Vendors Association. That is also lying pending before this honorable division bench, Your Lordship. In that case, I, on behalf of the Revenue Department, have filed an affidavit, Your Lordship, stating the counterclaim regarding whatever being stated in the writ petition.
So we'll list this all.
Yes, together it can be listed, Your Lordship.
Will issue notice.
Yeah, in the meantime, I'll file my affidavit in this case.
Petition. Issue notice. You are appearing for
For revenue.
MS
And borderline.
and Borderland and Standing
Correspondent.
Council Revenue
1. Yes,
Department appears for respondent
1.
1.
I think
Chief Secretary,
Chief Secretary.
Lordship, yes, Lordship. I'm appearing for respondent number 2, my lord.
MS,
MD Bora, my lord.
MD Bora, Leonard, Government Advocate
Lordship.
for respond number 2. How about 3?
For 3, I can appear.
Okay, 1 and 3. And 2. Petitioner to take steps for service of notice and respondents. 4 and 5. By registered post AD within 1 week,
Yes, Lordship.
list after 4 weeks.
My lord, GA Assam may be reflected
1
above
minute,
this.
list after 4 weeks, along with WBC number.
WPC 5572 of 2023, All Assam STEM Vendors Association. versus State of Assam.
5572.
Lordship, GA Assam may be reflected in the cause list.
Registry directives to reflect the name of the government of Assam in the cause.
Copy may be also served to us.
My lord, yes, Lordship. My lord, one more prayer. With regard to para 5, there was certain mistake. So I was pleaded before this honorable court for correction of those. I have filed an affidavit and that has been tagged, Lordship. So while taking steps, I may that may be
No, you can't correct it by way of an affidavit.
Lordship.
You'll have to file an IA.
I obliged, Lordship.
Item 3.
Obliged, Your Lordship.
May I please, your lordship?
Yes.
My lord, this matter Waqf property PIL.
Yeah.
My lord, our plea is very limited, my lord, from the various RTA information, my lord, which we have received. The large scale encroachment is already there, my lord. So, my
Let
lord,
us see what they reply.
my lord, my-
Lordship, I just want to submit one thing, my lord. This is the allegation this PIL is there, their land is encroached by someone. But deputy commissioner of the concerned district were not a party here, Lordship. The deputy commissioner is a necessary party in this PIL, my lord. So
Lord,
that they
Deputy
can.
Commissioner has to do nothing, my lord.
No,
The
no,
Waqf
Lord.
board is there, my lord. If we, my lord, if we go by the statute, my lord, there is a board, Waqf board is required to look after under section 54 of the Waqf Act. my lord.
Okay, we'll see when
My lord,
after you
my lord.
file your affidavit.
Lordship.
Third, Mr. A.R. Guyan and the county petition. Issue notice. You are appealing for
1 and 3, my lord.
MSND Bora,
Standing council.
Standing council,
WMD department.
WMT appears for the respondents, 1
1
and
and
3.
3.
You take steps on respondent 2.
My lord.
Petitioner to take
Yes, my
service of notice on respondent number 2 by registered proceeding within 1 week.
My lord, by Dasti mode can also be given, my lord. It is very
1
nearby,
week,
my lord.
1 week from, you take registered
My
post. Additionally,
My lord.
the petitioner is also permitted to take steps for service of notice on respondent number 2 by dusty service to the registry of office.
My lord.
Drafter, petitioner shall file an affidavit to let them pay. List after 4 weeks.
Lordship.
May-
My lord. SCWMD may be reflected in the cause list,
It's not there.
not
No, my lord,
reflected.
only
The registry is also directed to reflect the name of standing council, WMP in the post list.
I'm deeply obliged, my lord.
obliged. Lord.
For admission item 4.
Please, your lordship. This matter, your lordship, has heard it on other day, but as Honorable Justice Kadek was not there on that day, I think I will have to start from the beginning. My lord, although the matter looks to be quite hefty one, point involved is very small. Now, here your lordship will find your appellant, my lord, has been serving as an assistant professor and head of the Department of Computer Science and Application in the Karimganj College, which is the affiliated college. My lord, he has been working since 2005 as regular assistant professor. Now, my lord, he acquired his MPhil degree in the year 29/9/2008. The date is very important, my lord.
29?
29/9/2008. And PhD degree in the year 25/2014.
25?
2014. Now, on 29/9/2008, on this date, he became UGC qualified teacher. Now, my lord, here what happened? My lord, I am required to get 5 marks on MPhil and 5 marks in teaching experience. Now, he has acquired his MPhil degree in the year 2008. And the date of advertisement, your lordship will find 2017. Now, from 2008 to 2017, my lord, I acquired 9 years of teaching experience. So therefore, I'm admittedly, my lord, I am entitled to 5 marks there also. And out of 3 of the institution, the lordship has seen the last time that 2 of the institution, they have rightly given 5 marks on MPhil and 5 marks on teaching experience. But only one institution, they did not give 5 marks on MPhil. They have given 0 marks and 2 marks on teaching experience for the reason best known to them. Now, pursuant to advertisement on 8/5/2017, I applied for the post of regular assistant professor in all these 3 institutions. And my lord, the mark is given in terms of the office memorandum dated 25/6/2012. My lord, I will take your lordship first to that, which your lordship will get at page 84, my lord. Page 84, this is the office memorandum dated 25/6/2012. Your lordship may turn to page 85. Down below, your lordship kindly see distribution of marks. Academic record and research performances. Your lordship has seen that. My lord, there is no dispute. Now, your lordship kindly come to page 86. 86, your lordship will find the top, research performance. PhD from UGC recognized. My lord, I did not ask any mark for PhD. That's why it is undisputed. I'm not arguing on that. Now, then your lordship kindly see MPhil degree from UGC recognized and Government of Assam approved university. 5 marks. Now, this honorable court, while adjudicating the matter, my lord, this honorable court has said that the degree I have obtained, MPhil, is a valid degree because nobody has challenged that. Now, I am entitled to 5 marks there. Then your lordship kindly see down below teaching experience. Column 2, my lord, in the middle part. Teaching experience, 5 marks. 1 mark each completed year of service in an affiliated government degree college, subject to maximum 5 marks. So since, my lord, I have qualified to be UGC qualified teacher on 2008 and till the date of advertisement, that is 2017, my lord, I have acquired 9 years of service. So maximum marks I can get 5. So I'm entitled to 5. And 2 of the institution have given 5 marks each, all these. Only the Dalgaon, that is the institute, they did not give. Now I'll take your lordships to the institution which is given what marks, my lord. At page 6, your lordship kindly come at page 66. This is the marks given by Amjanga. This is one of the institution, my lord. Page 66. My lord, your lordship will find serial number 68, Rajiv Das. He is the applicant before your lordships. Now, in MPhil marks, your lordship will find he has got 5 marks rightly given. Then teaching experience, he has given 5 marks. Now, in the extreme right-hand side, your lordship will find not eligible to non-proficiency in local language. Now, your lordship kindly see, he has secured 2nd position, but because of this remark, he has not been accommodated. Now, what this honorable court has said, your lordship will find this has been set aside by this honorable court while adjudicating this matter. Your lordship will find that at page 183. Page 183, paragraph 19. Therefore, unless the respondent authorities demonstrate from any act, rules, notification, etc., that any local language has been prescribed for Dalgaon, the rejection of the candidature of the petitioner on the said ground is legally unacceptable in light of notification dated 31/3/1964 contained in the Handbook of General Circulars 1965. Moreover, the learned senior counsel for the petition has successfully demonstrated that in the evaluation sheet which was provided to him through RTI, there is no such remark by the panelist who had interacted with the petitioner and evaluated his merit. Therefore, the remark not having proficiency in local language, which is mandatory as per the advertisement, which is contained in impugn order dated 18/7/2018 by the Director of Higher Education Assam, thereby disqualifying the petitioner, is held to be a manufactured ground and not existing in the record. It may be mentioned that as per RTI reply furnished by so-and-so, his candidature at PDM Amjanga was rejected for the reason not eligible for non-proficient in local language. In respect of Tulungia, his candidature was rejected for the reason General MI Bengali, so not recommended. Therefore, the lack of proficiency in local language being one of the reasons to deny appointment to the petitioner by impugn order dated 18/7/2018 is also rejected. So therefore, my lord, if your lordship turn around and page 66 once again, your lordship will find this quite arbitrarily they have rejected my candidature because non-proficient in local language. Because the honorable single judge has set at rest that saying that this portion is set aside. Then the reason, my lord, then your lordship kindly come to page 70, my lord. 70. Here, your lordship, I am just showing that the subject expert is one Professor Tulsi Bajborua and Abhijit Sharma. Why I am taking your lordship here, the same subject matter teacher, my subject expert, he has given 5 marks in Amjanga, Tulungia, but same subject expert has given 0 mark in MPhil in the Dolgao and 2 marks in teaching experience. Now, your lordship, now come to page 72, my lord. This is in regard to Tulungia, my lord, another institution. Your lordship will find Rajiv Das in the middle part. He has got 5 marks in MPhil and 5 marks in teaching experience. Now, these marks are very rightly given because I am entitled. Then, your lordship, next page 82, my lord. '82 is the Dalgaon. Rajiv Das, serial number 52 in the middle part, you also will find. This institution has given MPhil 0. Then teaching experience 2. And thereby, my lord, I have been ousted from there. Now, your lordship will find, my lord, in the last occasion, I have given a small note. I'll take your lordship to that. Yes, sir. Hello. Honorable Justice Kaddak, I don't think your lordship has that copy.
Yes, we have.
My lord, I'll take your lordship to that. Your lordship, kindly see the last page. The notification dated 1st January 2011.
1 minute. Then I'm not.
Lord, I can hand over another one. Yes. Now, the last page, your lordship kindly see. Well, the last page, your lordship will find the notification dated 1st January 2011. In continuation of the department's notification dated 7/10/2009 and PO of University Grants Commission decision to examine all candidates who obtain MPhil degree, PhD degree on or before 10th July 2009 from clearing NET to qualify for appointment as a teacher in colleges and universities by UGC's resolution number so and so and meeting held on 27 September 2010. The same is notified as follows. The Commission further resolved that since both the above mentioned regulations are prospective and not retrospective in nature, therefore all candidates having MPhil degree on or before 10 July 2009 shall remain exempted from the requirement of NET for the purpose of appointment as lecturer, assistant professor. Further, all candidates who have either obtained PhD degrees on or before 31st December 2009 and candidates who had registered themselves for PhD degree on or before 10 July 2009 and are subsequently awarded PhD degree shall remain exempted from the requirement of NET for the purpose of appointment as lecturer, assistant professor. My lord, although your lordship will find, so far my MPhil degree is a valid degree, the learned single judge has said. Nonetheless, my lord, my learned friend of the other side, the other day, tried to argue on that. Then, my lord, I made a submission that this part has already been, my lord, set at rest because you did not file an appeal. Unless you file an appeal, you cannot make any argument. In spite of that, I will try to convince your lordships that whatever the adjudication made with the learned single judge, it is right on the basis of record available here. Now, I will take to your lordships the MPhil certificate which I got, which your lordship will find at page 54 of the appeal. This is my MPhil degree.
Yes.
Lord, this is the Faculty of Engineering and Technology, Annamalai University. And then is Computer Science, Master of Philosophy in Computer Science, she having been certified by duly appointed examiners to be quantified to receive the same at the examination held in September 2008, and that she is placed in the first class. Now, this is for the academic year 2006-2007, which your lordship will find in my pleading at page 39. It was not necessary, but they will start saying all these things once again. That's why I'm clarifying it. Now, page 39, your lordship can listen. Well, start from page 38, paragraph 27. That your petitioner states, lordship got it.
Yeah.
That your petitioner states that the submission made by Standing Counsel on behalf of DHE, Assam, before the Honorable Guwahati High Court, he tried to inform the Honorable Court, as recorded in paragraph 4 of the aforesaid Honorable Court's order dated 4/9/2017, and the petitioner's MPhil degree from Annamalai University is not recognized under central government communication dated 29/8/2006, which is not the correct state of affairs. The said communication dated 29/8/2006 clearly stated therein that the MPhil courses should not be offered through distance education from the academic year 2007-2008. The said communication dated 29/8/2006 has no relevance to petitioner's MPhil degree, which relates to the academic year 2006-2007, bearing enrollment number so and so. The confirmation of admission in the MPhil course was dated 19/12/2006, much before the academic year 2007-2008. Now I am showing your lordships the communication dated 29/8/2006, what they have said, which your lordship will get it at page 104. 105, your lordship may come. No, 104, may. Annexure 22. This is from Thiru Ganshan IS, Secretary to the Government, to all the universities. Now, subject is offering of MPhil PhD courses through distance education by universities dispensed with effect from the year 2007-2008. Now, your lordship kindly see since when it has been dispensed from 2007-2008. Now, I have acquired this MPhil degree, as your lordship has seen. It was the academic year 2006-2007, before this. So therefore, the learned single judge, after perusing all these things, Melody has said that the MPhil degree is valid and it has not been challenged by anybody. Now, in the Vice Chancellor's meeting held on 21/8/2008, under the chairmanship of Honorable Minister of Higher Education, the issue relating to dispensing with the system of offering MPhil PhD courses through distance education was discussed in detail. The government, after careful consideration, directed all the universities under the aegis of Higher Education Department that MPhil PhD courses should not be offered through distance education from the academic year 2007-2008, and they should be offered only in the regular stream. So therefore, my lord, this has not affected my degree since I have obtained that before this period.
So you took from distance mode?
Yes, yes, that is admitted, my lord. And then also, my lord, I am coming further. The lordship will find the government till 2013 accepted the degree obtained through distance mode, and they have appointed, even regularized those professors. I am taking to your lordship, which I have, my lord, pleaded in my affidavit in reply. I'll be taking to your lordship to that. Your lordship, kindly see at page 143, my lord. This is my RTI letter to the principal of the colleges and the director of higher education. My lord, at page 143, from Dr. Rajiv Das to MS Chinmay Talwakdar, SPIO, Director of Higher Education. The subject matter your lordship will find: provide the list of in-service college sanctioned teachers, lecturers, assistant professors, librarians who have got no objection certificate from DHE, Assam, for their higher education MPhil through distance education mode and subsequently became permanent and got promoted on acquiring the MPhil degree. Now they have given the reply, which your lordship will find in page 145. His Director of Higher Education informed to the principal of all provincialized degree colleges of Assam. The contents is: in inviting a reference to the subject cited above, I am directed to transfer herewith the RTI petition of Dr. Rajiv Das and section so and so, and request you to kindly submit the required information document of the said petition directly to the petitioner with an intimation to the undersigned. Now, at page 146, your lordship will find to Dr. Rajiv Das. With reference to the subject cited above, I have the honor to say before you the following few lines. No objection certificate not available. Following assistant professor acquired MPhil through distance education mode: Mr. Mahendra Dole, Department of History, Mr. Swan. So there's 4 persons. Then the following assistant professor acquired MPhil degree through distance mode and subsequently became permanent in service under DET Assam. Mr. Mohendra Dole with effect from 1/10/2008, Mr. Hemanta Shaikia with effect from 20/2/2009, Dilip Kumar Boda with effect from 2/2/2009, Mrs. Reena Shaikia 5/9/2008. Even this is after the cutoff date. The government has accepted. Now they have been promoted on acquiring MPhil degree. Now your lordship will find when they have Mohendra Dole 13/12/2008, they have got promotion. Now, my lord, your lordship may skip this paper. Then the next I will take your lordship to page 164. This is in regard to Bongaigaon College. Everywhere your lordship will find this. They have got their MPhil degree for distance mode, and after the cutoff date, even then the government has accommodated them. Page 64 to Dr. Rajiv Das. In response to your letter, the undersigned is submitting here with the following information: RTI Act. Case number 1, there is no permanent employee who got no objection certificate from DET and their MPhil degree in the distance mode. We appointed 4 employees who obtained MPhil degrees from distance mode during the stipulated period. Now the next page your lordship will find Mallika Bhattacharya passed from the university, this Binayak Mission University, in the year 28/3/2013. She passed in the year 2013, and my lord, she have been accommodated, she have been confirmed in her service. And in my case, my lord, they are making this objection. My lord, seeing all these things, learned single judge rightly say, my MPhil degree is a valid one, because the government is accommodating even after the cutoff date, and they are finding fault. Although I have received it in 2006, 2007, they are saying the degree is not valid. Now, this argument was not required to be made, since there is a clear finding of the learned single judge. But why I am making, your lordship has seen the other day what happened. Lord, even I have taken your lordship to the finding of the learned judge that this has set at rest. My lord, they did not file any appeal. Even then they were arguing.
Let us see that observation.
Yes, yes, that at page 188 minute. My lord, I will start from page, yes, page 188. While examining from there, your lordship can listen. While examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in the concerned college without commenting on validity or otherwise of the degree, as the validity of the degree is not under challenge on question. Now, in view of these findings, well, this argument is not necessary at all, because it has reached its finality. Nobody has challenged this. So therefore, this is why I'm making this argument, because they will start saying that. Before that, I want to make it clear that how this finding was given. Now here, your lordship has seen at page 165 once again. Mallika Bhattacharya, she is from Bongaigaon College, and date of appointment 28/5/2007, passed from the university, Binayak Mission University, distance education mode, on 28/3/2013. And the next candidate passed on 23/3/2007, the other one 9/10/2009, then 16th August 2011. Now they are not questioning all these things. Then Hojai College, there are plenty. I am not taking to your lordship. Then your lordship, kindly see at page 168. This is from the same college where I am, my lord, at page 168, your lordship, kindly see Karimganj College, Karimganj. Well, I am teaching in that college. With reference to letter cited above, I am furnishing here with the point-wise information to meet your requirement. One in-service teacher acquired his MPhil degree from distance education mode, Madurai Kamraj University, and subsequently became permanent. Withdrawn the conditional appointment on 15/4/2009 as per DHE order number so and so. Then your lordship will find Muhammad Zakir Hossain Chaudhary, Assistant Professor, Department of History, from the same college, my lord. Now he got the MPhil degree from Madurai Kamraj University in the year 15/4/2009 from the Karimganj College where I am teaching. Now, in the second, your lordship will see Atul Kumar Paul, Assistant Professor, Department of College. Date of joining is 27/2/2012. He got his MPhil from Binayak Mission University, 2009. Then another teacher, Manideepa Gop, Assistant Professor, Department of Commerce from the same Karimganj College. She got the degree from Annamalai University from I got in the year 2008. Now all these things make everything clear that, my lord, the government was until 2013 made all these appointments to these teachers. Therefore, my lord, when Learned Single just found all these things in the record, then he said that the MPhil degree which was acquired by the petitioner in the academic year 2006-2007 is a valid degree, and therefore, my lord, since it is without any challenge, it is not required, your lordship is not required to go into all that. Only because they made such argument, I took your lordship here. And the stand of the other side, my lord, I will take your lordship to their affidavit. What they have stated, they can argue within the scope of that affidavit in opposition only. Your lordship may come to page 129, which is the affidavit in opposition of the respondent number 2. Your lordship may look at page 130, paragraph 6 onwards. That with regard to the statement made in paragraph so and so, in the writ petition, the deponent state that it is a matter of record and put to the writ petitioner to strictest proof thereof and denies everything which is beyond the records. It is stated that the writ petitioner has obtained MPhil degree on 29/9/2008 through distance mode from Annamalai University, Chennai, while he was serving as assistant professor in the Department of Computer Science and Application in Karimganj College, Karimganj. Further, as per the Government Office Memorandum Wide Number dated 9/7/2012, it is clearly reveals that the writ petitioner is not eligible for getting marks for his MPhil degree. Now, these lines, my lord, they are saying that these document 9/7/2012 stipulates that the petitioner will not get marks to the MPhil degree. Now, where from he is getting? My lord, I am taking to your lordship that paper 9/7/2012. My lord, your lordship may kindly see page 141. This is the office memorandum they are referring in their affidavit in opposition, dated 9 July 2012. Government of Assam is aware on the issue that off-campus centers, study center, and the center operating through franchises are opened in the state by the universities outside the territorial jurisdiction of their universities. However, in view of the decision of the Honorable Supreme Court of India, in case of Professor Yashpal and another versus State of Chhattisgarh and others, no university can start any off-campus centers beyond their territorial jurisdiction of the concerned university as specified. Recently, it has been reported that there are a large number of such off-campus centers of other Indian universities which are functioning in Assam, in spite of Honorable Supreme Court judgment against such off-campus centers, study centers, in view of the aforesaid Honorable Court judgment and with a view that such off-campus centers which are existing are in violation of Supreme Court order, the following direction, you also will see that what are those directions. The following direction shall come into effect immediately. Number one, that concerned university shall ensure that no off-campus center, study center, and the centers operating through franchises are opened by the university outside their specific territorial jurisdiction in view of the judgment, so and so, so and so. Number two, in case a university has already started an off-campus study center, violating the Supreme Court's order, and the centers are operating through franchisee in the state, the same is to be closed immediately. Number three, no distance education program shall be started without the prior approval of the Distance Education Council, the regulatory body for distance education programs. The government, with virtue of these office memorandum dated 9 July 2012, has clarified that it is the against the decision of the appeals court. If any off-campus through distance mode is there, that will have to be stopped immediately. So therefore, it hasn't said the person who has already acquired the MPhil degree within the cutoff date, they will not get much, although the degree is valid, they will not get any marks. It hasn't said anything, whereas their affidavit they have said, further as per the government of office memorandum dated 9/7/2012, it has been clearly revealed that the writ petitioner is not eligible for getting mark for his MPhil degree. Quite funny, my lord. This office memorandum hasn't said so. This has only said that whatever the off-campus mode system is there, henceforth it will have to be stopped. That is the only indication it has been given. Now, my lord, I will take your lordships to the, I'll read from that short note which I had given to your lordship. My lord, rather let us go to the impugned judgment. Then I will take your lordship to that. Impugned judgment, your lordship will find at page 169. It starts from page 171. I'll read from paragraph 2. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has prayed for directing the respondent authority to award appropriate marks to the petitioner in accordance with Office Memorandum dated 25/6/2012 in MPhil and teaching experience, and thereafter to appoint the petitioner in the post of Assistant Professor Information Technology, Computer Science. The petitioner has projected that he is serving as Assistant Professor in the Karimganj College since 1/7/2005, and presently he is the head of the Department of Computer Science and Application under self-financing scheme in the said college. The petitioner had acquired PhD degree in computer science from Assam University, Silchar, which was conferred in the 14th convocation held on 15/11/2014. In course of service on 19/12/2006, the petitioner got himself enrolled in MPhil degree course in Annamala University under distance education mode after obtaining no objection certificate from his employer college. The petitioner was awarded his Master of Philosophy in Computer Science degree by the said Annamala University in the examination held in September 2008, and he was placed in first division. Pursuant to employment advertisement dated 2/5/2007, so and so issued by the respondent number 4, 5, and 6, respectively, the petitioner had applied for selection and appointment to the post of Assistant Professor in the Pandit Deen Dayal Upadhyay Adarsh Mahavidyalaya at Amjanga in Gwalpara district, Tulungia in Bongaigaon district, and Dalgaon in Darang district. The Learned Senior Counsel for the petitioner has submitted that though the petitioner appeared in the interview process held on different dates, but by granting war marks by ignoring his entitlement, his candidature was rejected. The point raised by the Learned Senior Counsel for the petitioner is discussed issue-wise The issues raised are summarized as follows. Whether the petitioner was awarded lesser marks by not treating time spent for pursuing MPhil and PhD degree as teaching experience. Whether the petitioner was illegally denied marks despite having MPhil degree. Whether the petitioner was awarded lesser marks by UF hostile discrimination on account of language. On whether lesser marks was awarded to the petitioner by not treating time spent in pursuing MPhil and PhD degree. Now, before I start this point, my lord, now, your lordship, my argument before the honorable single judge was that I am entitled to get 5 marks because of the MPhil degree and 5 marks for teaching experience. Because I have a teaching experience, the day I have become UGC's qualified teacher on 2008, after getting the MPhil degree, my lord, I continue to gather experience as teaching experience till the date of advertisement, that is 2017, for long 9 years. However, I will not get 9 marks. The maximum mark I can get 5. So I am entitled to get 5 marks. So therefore, my first primary submission was that I am entitled to get teaching experience of 5 marks as I have gathered 9 years of service as a teaching experience. Now, the London single judge construed that the experience I am to get teaching experience in PhD. Well, your lordship will get no heading experience in PhD in the office memorandum dated 2012. That was some confusion arose possibly, and therefore your lordship will find in the judgment is given the finding that the MPhil 5 marks and not teaching experience. London single judge said experience in PhD. Therefore, the entire thing went on a different case, which is not our case, and which is not spelled out in the office memorandum dated 2012. So I'll take your lordship to all these things. Now, he relied only on my alternative submission, the time spent while pursuing my research study, simultaneously along with the time spent for teaching assignment. Because I was, without taking leave, I was pursuing my studies along with my lord simultaneous teaching assignment. So he thought that is the only point, and therefore he said that I am not entitled to get that marks while I was pursuing my research studies. That is not required at all, man. Now, if your lordship ignore that also, I am having my experience, teaching experience after getting my UGC qualified teacher 2008 to 2017. So learned single judge is given focus to this one. So that is my whole contention. Now, your lordship will see what the learned single judge said. The learned senior counsel for the petition has submitted that at Dalgaon, the petitioner had been given 8.01 marks less. In Tulungia, he was given 103 marks less, which is in violation of OM dated 25/6/2012. It is also submitted that as per the petitioner's assessment, he was ideally entitled to 63.94 marks amongst others, because the petitioner was entitled to 5 marks for teaching experience, 5 marks for his MPhil degree, and 5 marks for PhD. This is not correct, Milo. I am not entitled to get any marks in PhD. So therefore, it was not my contention. Now, somewhere my lord learned single judge thought that I am entitled to get 5 marks in PhD. My lord, why I am not entitled to get 5 marks on PhD? Because, my lord, if I get PhD without net, my lord, I'll clarify it by showing the office memorandum. My lord, factually so cumbersome in this case. At page 84, my lord. Your lordship, kindly come at page 86. On the top, research performance, PhD from UGC recognized and Government of Assam approved university. if the candidate has PhD degree in addition to eligibility requirement of a NET/SLAT. Now, if I am having PhD in addition to this, I am entitled to 7 marks. Now, there will be no marks. This is in my case. There will be no marks for the PhD degree if it is counted in lieu of NET/SLAT. Now, I did not have NET/SLAT. Therefore, my lord, I did not ask for because I am not entitled to get any marks there. Now, the learned single judge thought that I wanted marks there also. Now, therefore, my lord, I am taking to your lordships to clarify why I am not entitled to get any marks in PhD. Because that scope is not there because I did not have any NET/SLAT and all. Now, my lord, that 5 marks, then again, pays at 173, my lord.
Yes.
Five marks PhD degree. Therefore, my lord, this is not correct. I am not entitled to get, and I did not ask for it also. The chart showing marks awarded were as follows. Now, this is the chart, my lord. This page, your lordship may come at page 174. Then your lordship may look at MPhil. MPhil in Amjanga, my lord, they have given 5 marks for MPhil. Tulungia also given 5 marks. Dalgaon has given 0. Then your lordship kindly come down to teaching experience. Teaching experience, Amjanga, they have given 5. Tulungia, they have given 5. Dalgaon, they have given 2. To project entitlement of the petitioner to 5 marks for teaching experience, it is submitted that although under office memorandum dated 25/6/2012, it was provided that the period of time taken to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the positions. But wide communication under DO number so-and-so dated 1/3/2016, the Secretary UGC had clarified that the period of active service spent on pursuing research degree, that is for acquiring PhD degree simultaneously without taking any kind of leave, may be counted as teaching experience for the purpose of direct recruitment, promotion to the post of associate professor and above. Accordingly, it is submitted that the MPhil degree being research-based, the same principle would apply there also. Par contra, the Learned Standing Council for the Higher Education Department has countered the communication of the Secretary UGC dated 1/3/2016 by submitting that as per clause 3.9.0 of the University Grants Commission on minimum qualifications for appointment of teachers and other academic staff in universities and colleges and measures for the maintenance of standards in higher education, Regulation 2016, published in the official gazette by UGC notification dated 4/5/2016, it is provided that the period of time taken by candidates to acquire MPhil and or PhD degrees shall not be considered in teaching research experience to claim for appointment in teaching positions. In the office memorandum dated 25/6/2012, it has been mentioned in clause 7 thereto that the period of time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the position, clause 3.9.0. The Learned Standing Council for the Higher Education Department has demonstrated that the reference regarding so-and-so as mentioned in clause so-and-so in the said office memorandum dated 25/6/2012 is preferable to UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges and measures for the maintenance of standards in higher education. Clause so-and-so, so-and-so. Now, this part of the thing, your lordship may skip, then paragraph 10. Now, the learned single judge was dealing mostly of my alternative argument, which is, my lord, if your lordship accept that I have sufficient experience, your lordship need not go to all that thing. Now, in paragraph 10, my lord, thus the point for determination, number A is answered by holding that the respondent number 2 had not committed any illegality in refusing to consider marks to the petitioner by treating time spent for pursuing MPhil and PhD degree as teaching experience, notwithstanding that the petitioner might have actually rendered service to his college during that time. Now, learned single judge has landed in error by giving this finding, because, my lord, he's sending it back to the higher education. Now, what is the thing, my lord, what is the finding is given? I'm reading once again. So the point of determination number A is answered by holding that the respondent number 2, respondent number 2 means Director Higher Education, my lord, had not committed any illegality in refusing to consider marks to the petitioner by treating time spent for pursuing MPhil and or PhD degree as teaching experience, notwithstanding that the petitioner might have actually rendered service to his college. Now, if your lordship finds, otherwise I am having the experience. Now, time spent in my research study, if you do not count also, then also I am having sufficient experience after UGC qualified teacher from 2008 to 2017. Now, this finding is creating a problem when it will go to the Director High Secondary. What will do? The High Court has already said that we did not commit any mistake. And my lord, this finding was quite unnecessary even. First submission, if you consider, why you should fall back to this, which is not necessary exercise at all. Therefore, you did not say anything about my first submission that I am having the sufficient experience. And you were saying that the respondent number 2 had not committed any illegality. Now, if you do not give any marks while I am pursuing my research study simultaneously with teaching assignment, if you do not give any mark there, it's not necessary also, because sufficient experience I am already having prior to that. Now, this finding is wrong because of this, my submission is this, because it was not necessary to make, if you do not give any marks, so far my teaching experience in regard to while I am pursuing my research studies along with my teaching assignment, if you do not give marks also, I am having sufficient experience prior to this. So therefore, this is absolutely a perverse finding.
The issue is you got your MPhil in 2008.
2008, yes.
Correct. Then you did your PhD when?
PhD 2014. I'm not touching PhD even. Let us be confined up to MPhil. MPhil I have acquired 2008, and then UGC qualified teacher from 2008. My experience from the date of advertisement is 2017. Now I sat in the interview in 2017 May. Now this period I am having my teaching experience. Now learned single judge did not go to that even. If this experience period, if you count, why you drag me there? That even this teaching experience for long 4 or 5 years, I am not. If I am not entitled, also I am having the sufficient teaching experience for 9 years. No, he did not count that. That's the problem. If you count that, this is quite unnecessary. Therefore, this finding is totally perverse and without consideration of my primary submission made in the court. Then, my lord, next, whether the non-accept.
Discontinued for MPhil in the state. How could this certificate can be issued? Because there is no economic session for 2006, 7 and 8.
No, his MPhil is 29/9/2008. 29/9. You can ask.
For this academic session of 7 and 8 has been discontinued.
Yeah.
Once it is discontinued, how the certificate should be 8?
You want to ask a question? You can ask, these are just clarified. No, that's the one question.
Well,
This 2006, 7 and 2008,
Hmm.
that academic session has been cancelled.
that is, my lord,
That where from where you have obtained this MPhil degree.
yes, that I have already took your lordship there. I am taking once again. My lord, if your lordship see at page 104.
104.
Annexure
Yes.
22, my lord.
Okay.
This is the letter from the Secretary to Government to all the universities. Higher education offering of MPhil PhD courses through distance education by universities dispensed with effect from the year 2007-2008 orders issued.
Yeah.
In the Vice Chancellor's meeting held on 21/8/2008 under the chairmanship of Honorable Minister for Higher Education, issue relating to dispensing with the system of offering MPhil PhD courses through distance education was discussed in detail. The government, after careful consideration, direct all the universities under the aegis of Higher Education Department that MPhil PhD courses should not be offered through distance education from the academic year 2007-2008, and they should be offered only in the regular stream.
Hmm.
Now, this has said from 2007-2008.
8.
My degree was prior to this.
No, your certificate is of 2011, 2008.
Yes, but that relates to academic year 2006-2007.
According to you, since you have already admitted in 2006 to 2007, but you it says page 55.
Page 55.
This is MPhil.
This is the MPhil degree.
55, 54. MPhil.
Yes, 54, my lord. This is the year of the certificate was issued on 2011-2008.
Yes.
It relates to academic year 2006-2007.
That is your submission.
Yes, that document.
Once you got the admission, even after discontinuation in of the academic session 2007 to 2008,
My lord.
certificate can be given in 2008.
Because it is prior to that. Because your lordship can see one thing. They have clarified that after 2007-2008, if anybody they cannot obtain. That has been, my lord, they have given a shield that before, prior to that day, it is all valid.
No,
They haven't said that.
104 doesn't say so clearly. It said it should not be offered.
Yes, that is, my lord, your lordship.
2007 to 2008.
The government, after careful consideration, direct all the universities under the aegis of Higher Education Department that MPhil PhD courses should not be offered through distance education from the academic year 2007-2008, subsequent to my getting of the MPhil degree. My lord, that paper also I can furnish to your lordship. In the before the single judge also he placed it.
So according to you, this your certificate.
Yes. My lord, the matter will be very clear if your lordship look at this. This is in the record also because before the single judge we placed this. Your lordship will find Rajiv Das, academic year 2006-2007, enrollment number so and so. My lord, I'm just, my lord, taking your lordship to all this. It is not necessary at all because of the finding of the learned single judge.
But
Because his lord
Leonard Single has said without commenting on the
validity
or otherwise.
Validity of the degree, yes.
No comment.
No
There's
comment.
there's no-
Of
I
course,
mean-
there is, but they ought to have challenged that. Nobody has challenged. It has reached its finality. Now, my lord, supposing one thing, your lordship has given a judgment and nobody is challenging, it reached its finality.
No, it is a finding. Validity or otherwise of the finding, then of
No,
course,
because nobody has challenged. His
it has
lordship
put-
has said,
it has put to rest if it is not challenged. But
Yes.
Leonard Single judge has said he's not commenting.
no, the learned single judge has said
Leonard
nobody has
Single
challenged.
has not commented on the validity or otherwise of your certificate.
My lord, if I go to, yes, that is your, because after seeing all that, your lordship, there is no challenge. 188, your lordship, once again, kindly come. I'll read that paragraph. While examining the page 188, my lord. While examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in the concerned college without commenting on validity or otherwise of the degree, as the validity of the degree is not under challenge and question. So therefore, when it is not under challenge, my lord, his lordship has accepted it. And when further, my lord, against this finding, there is no writ appeal, should your lordship go back to it to reopen the matter once again? So who has questioned this before your lordship?
It is
I am taking to your lordship,
open for the authority to examine
no, without,
regarding the validity or otherwise.
no, even that they also cannot do. Language is so clear, my lord, while examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle, your lordship, can you see the language, would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in the concerned college without commenting on validity or otherwise of the degree, as the validity of the degree is not under challenge. It is not open to them also.
Leonard
They will-
Single has just said that he has not commented on the validity, but it is open to the authority to examine.
My lord, with deep respect to your lordships, my lord, I will read again, my lord. While examining the matter, it would be open to the said authority.
To
To
examine.
what they will examine, my lord, I am clearing it. What they will examine, to examine whether MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the, they are saying they can only examine whether this will have any advantage to his appointment. His lordship is not saying you can examine the validity of the degree. It's not there at all. Your lordship, kindly see. So therefore, is only they will assess whether it will have any advantageous effect in regard to their appointment.
Not the questioning the valid.
No, not
Not
at all.
valid.
They cannot go to that area also. Because the finding is so clear, whether it will have some advantage to his appointment. This is the only area where the authority can go. But then my submission would be, when you have found my MPhil degree is a valid, automatically, my lord, why they have, my lord, this director has seen 3 times the High Court has remanded there. What they did nothing, my lord. Even this Honorable Court has passed an order of 25,000 as cost to the director. He hasn't paid till today. They are violating in every respect, my lord. So much of audacity. What they do, they will just reject. Now, therefore, this matter is so simple. Whether I am eligible to get 5 marks for MPhil, whether I am eligible to get 5 marks for teaching experience. This is the area only your lordship will go into. Now, whether when I was, my lord, pursuing my studies as research studies, subsequently with my teaching assignment, if I do not get any 1 mark there also, it's not affecting my case. Your lordship need not travel to all these.
So you are agreed by para 10 and the consequent demanding.
Yes, exactly, my lord. Now again, let
Other
me,
findings are in your favor.
other findings, my lord, the local language, I am poor, all these things, my lord, it has been deprecated to the Supreme Court in so many cases. Because it goes against Article 15, 12, 16, all these things. Now, yeah, possibly I was reading the judgment, my lord.
Para 10.
Beg your pardon?
You're reaching para 10 of the judgment.
Para 10, yes. My lord, when you ask me such questions, I again forgot. Para 10, my lord. Now, thus the point of determination number A is answered by holding that. Now that I have explained, my lord. Then the point of determination number 2 and 3 are taken up together. The petitioner had initially approached this court by filing WPC. Your lordship may come to page 178, para 14. It is seen that in this order dated 18/7/2018, the Director of Higher Education has admitted that there are 4 sanctioned posts of assistant professor in computer science in Dalgaon, and that advertisement had been issued for filling up all the 4 posts. Accordingly, while the candidature of the petitioner was rejected, 4 candidates, namely so and so, were appointed. However, Sri Shubhma Dev had expressed his unwillingness to join, and therefore the other 3 candidates were appointed. The Director of Higher Education had again reiterated the observation made in the said authority's earlier order dated 24/1/2018 that as such, even if Sri Rajiv Das is given the marks for teaching experience and MPhil degree, then also he cannot be given the post as the college has very less enrollment. The court finds the reiteration of the said observation not only unjustified, but is again a blatant attempt to overreach the order dated 4/9/2017 passed by this court in WPC number so and so, order dated 16/3/2018 in WPC number so and so. In both the said orders, this court had emphasized that the director shall give a consideration as to whether the marks for having MPhil degree in the distant mode from Rangamala University and the marks in the heading experience for having pursued PhD degree should not be given to the petitioner. In the considered opinion of the court, as the Director of Higher Education Assam had admitted that 4 posts of assistant professor in computer science was advertised and was being otherwise filled up, but for the refusal of 1 selected candidate to join. It is not open for the Director of Higher Education Assam to change the stand that because of fewer students, the petitioner cannot be appointed. It may be mentioned that the recruitment process was initiated by advertisement dated 8/5/2017, amongst others, for selecting candidates for 4 posts of assistant professor in computer science in Dalgaon, issued by the Deputy Commissioner Darang Mangaldoi. A mention has been made regarding the communication dated so and so, issued by the Director of Higher Education. This would lead to a presumption that the Director of Higher Education Assam has approved of the advertisement for 4 posts of assistant professor in computer science, selected and appointed 4 candidates to fill up all the said 4 posts. But when the said authority has found that it would have to consider the claim of the petitioner, the Director of Higher Education Assam has found a convenient escape route by manufacturing a plea that there are less students in the concerned college. Therefore, from the above, the indelible opinion of the court is that both the then directors of higher education had blatantly attempted to overreach the order dated so and so passed by this court on so and so, order dated so and so, by manufactured plea that there was less enrollment of students in Dalgaon. The said reasoning by the Director of Higher Education in the MP order dated so and so deserves to be and is accordingly rejected. The learned senior counsel for the petitioner has been able to demonstrate that Bengali is one of the 3 languages of Assam. Moreover, it has also been demonstrated that as per the notification dated 31/3/64,
contained in the Handbook of General Circulars 1965, referred to herein before, the respondent authorities could not have discriminated the petitioner on account of his Amil in Bengali. Therefore, the rejection of the candidature of the petitioner on account of not having proficiency in local language, which is mandatory as per the advertisement, is not sustainable on facts and law. In this regard, the learned senior counsel for the petitioner had referred to the general circulars, and it is submitted that under para number so and so thereof, which is an extract of the notification under dated 31/3/64, the respondent authorities could not have discriminated the petitioner on account of his Amil in Bengali. The said paragraphs are quoted below. In accordance with the Public Employment Requirement 5 as to the Residence Act 1957, the state government prescribed a model form of advertisement, but to safeguard the interest of the people of the state, a knowledge of Assamese or Bengali or one of the tribal languages of Assam was prescribed as an essential qualification. Though the language condition covers most of the languages in Assam, yet the condition will put the linguistic minorities whose mother tongue is other than the languages prescribed is a disadvantageous position. It has therefore been decided to delete the language clause in the advertisement and henceforth an adequate knowledge of Assamese or Bengali or one of the tribal languages of Assam should not be prescribed as an essential qualification for recruitment. After initial appointment, a government servant should have an adequate knowledge of the language of the area in which he is posted. There are already rules for conduct of departmental examination in many departments wherein it has been provided that an officer, hello, your lordship may over these para. Now then para 18, my lord. In the aforesaid context, the London Standing Council for the Higher Education Department had submitted that the advertisement contained such a clause and therefore the petitioner having participated in the selection process without challenging the advertisement, the petitioner cannot be permitted to challenge. So this possibly you can skip because this the London single judge is given in our favor. So lordship may skip this. Then para 183, your lordship may come. Page 183, para 19. Therefore, unless the respondent authorities demonstrate from any act, rules, notification, etc., that any local language has been prescribed for Dalgao, the rejection of the candidature of the petitioner on the said ground is legally unacceptable in light of notification dated so and so contained in the handbook. The learned scenario for the petitioner has successfully demonstrated that in the evaluation sheet which was provided to him through RTI, there is no such remark by the panelist who had interacted with the petitioner and evaluated his merit. Therefore, the remark not having proficiency in local language, which is mandatory as part of the advertisement which is contained in impugn order dated so and so by the Director of Higher Education Assam, thereby disqualifying the petitioner, is held to be a manufactured ground and not existing in the record. It may be mentioned that as per RTI reply furnished, notice candidature, Amjanga was rejected for the reason not eligible for non-proficient in local language. In respect of Tulungia, his candidature was rejected for the reason Janal Amil Bengali, so not recommended. Therefore, the lack of proficiency in local language being one of the reasons to deny appointment to the petitioner by the impugn order dated 18/7/2018 is also rejected. Now, my lord, if your lordship take up the marks given in Amjanga, he got 5 marks in MPhil, 5 marks in teaching experience, and he got secured the second position in the list. Now, only he was rejected because no proficiency in local language. Now, when this is gone, I am entitled to get, my lord, even by creating a supernumerary post, learned single judge say. So, Amjanga also open, Dalgao is also open. Now, from the impugn order dated 18/7/2018, it is evident that the Director of Higher Education Assam had failed to perform duty cast on him to scrupulously act as per the direction contained in so and so. Then para 22, my lord. A specific direction was issued by this code by the order dated so and so to consider whether the marks for MPhil and experience. Now, your lordship, can we see the wording here? Experience in PhD. I have already taken to your lordships to the office memorandum in the year 2012. There is no head experience in PhD. It is teaching experience only. So learned single judge may not confuse there also. A specific direction was issued by this court by the order dated so and so to consider whether the marks for MPhil and experience in PhD, it ought to have been experience in teaching, should be added, and accordingly the order of 24/1/2008 by the Director of Elementary Education Assam was set aside, and the matter was again remanded back to the said authority to give an appropriate consideration as required by the order dated so and so, so and so. Now your lordship may skip, then para 23, my lord. The learned standing counsel for the higher education department had cited case so and so for the proposition that one wrong committed in one case cannot be allowed to repeat it in another. These are also not of great value. Your lordship may come to paragraph 24, my lord. Page 185. The decision of Union of India and others of Mahendra Singh was cited by the learned standing counsel for the higher education department to bring home the point that as the advertisement specifically contains that the period of time taken by candidates to acquire MPhil and or PhD degree shall not be considered in teaching research experience to be claimed for appointment in teaching position, and thus when there is a prescription to do a particular act in a particular manner following the principles laid down in case of Nazir Ahmed versus so and so, there is no quarrel with the point urged. However, despite such salutary principles, the Director of Higher Education should also have known that when this court had for the second time issued to it a direction to consider whether the marks for MPhil and experience in PhD ought to have been teaching experience should be added, the said authority ought to have taken a decision in the manner directed and not in any other manner or consideration. Therefore, as the Director Higher Education has failed to comply with the order dated 4/9/2017 passed in so-and-so, order dated so-and-so, for which we are inclined to hold that the MPhil order dated 16/3/2018 passed by the Director of Higher Education Assam is set aside and quashed. Now, your lordship, kindly see for a moment. Learned single judges say order dated 16/3/2018 has been quashed. My lord, these ought to have been order dated 18/7/2018. Because your lordship will kindly come to page 120. I'm clarifying that, otherwise there will be again some wrong proposition. Page 120. Now, 120, your lordship will find the order dated, order number DHE, your lordship kindly see in the left hand, extreme left hand side, DHE CE CC 51/2017/39. This is the number which the learned single judge has quashed. Now, date wrongly cropped up 16/3/2018. It ought to have been 18/7/2018. Now, the order set aside was 18/7/2018, not 16/3/2018. Now, your lordship kindly note that. For the reason as described above, as regards the point of determination number B and C, the court is of the considered opinion that the competent authority in the higher education department should take a call. We refrain from deciding the matter as it involves examining various notifications and office memorandums of the Higher Education Department of the State University Grants Commission, Indira Gandhi National Open University and Distance Education Council, and therefore such an examination is left to the Higher Education Department. Accordingly, we are inclined to remand the matter for fresh consideration by the authorities in the Higher Education Department, as it is for the second consecutive time that the Director of Higher Education Assam has not complied with the orders of this court. We are inclined to impose a cost of ₹25,000 on the Higher Education Department, Government of Assam, to be paid to the petitioner as cost of the litigation, which shall be paid to the petitioner within a period of 1 month from the date of receipt of the certified copy of this order. The government in the Higher Education Department will have the liberty to recover the said amount from the concerned officer posted as the Director of Higher Education, who had passed the MPN order number so and so, dated 18/7/2018, if so advised. It is seen that the Director of Higher Education Assam has not complied with the requirement of so and so's matter and has ventured on other irrelevant issues regarding less number of students and lack of proficiency in local language, which were otherwise irrelevant and not required to be gone into in light of the directions contained in the hearing before referred two orders of the court. Thus, we pass the following orders. The matter for a decision before the head of the department, Secretary Higher Education Department, whatever designation held, as to whether the non-granting of marks to the petitioner for MPhil and experience in PhD for selection and appointment as assistant professor is liable to be interfered with. The said authority shall take note of the grievance of the petitioner that pursuant to employment advertisement dated 2/5/2017, so and so issued by the respondent so and so, he had applied for selection and appointment to the post of assistant professor in Amjanga, Tulungia, and Dalgaon in the Darang district, but he was not given marks for MPhil and experience in PhD. Should have been teaching experience, was not added, and resultantly his candidature was rejected. While examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in the concerned college, without commenting on validity or otherwise of the degree, as the validity of the degree is not under challenge and or question. The said authority shall take note of the fact that in this order, we have already adjudicated and decided that the petitioner would not be entitled to marks for time taken by the petitioner to acquire his MPhil and PhD degree by considering it as teaching research experience to be claimed for appointment to the teaching positions. The head of the department, Higher Education Department, shall pass a speaking order within an outer period of 30 days from the date of service of the certified copy of this order on the said authority through his office. Needless to mention, whatever order is passed shall be communicated to the petition. Now, the last line, even the authorities of the view that the selection had appointment of the petitioner is entitled to be approved, the said authority shall pass an appropriate order for approval and appointment of the petitioner, if necessary, by creating a supernumerary post with the concurrence of other departments like finance, etc. Now, my submission would be, my lord, admittedly, my lord, there is no confusion at all. I am entitled to marks in MPhil and teaching experience. Two of the institution has rightly given me. Only Dalgaon has not given. The reason is not known to anybody. So for that reason, my lord, what is the need of sending back to the Director of Higher Education once again? Whereas three of the occasion your lordship has seen how he has dealt. He has said there is a less number of students. Lord, can it be ground? The single judge has deprecated this attitude of the director. They are bent upon, my lord, not to give me. What sort of ego fight I just could not, it is beyond any comprehension of anybody. You are saying you are not efficient in, or you do not have any proficiency in local language. Where from you are getting all that? You are ousting me everywhere. I have gotten second position. And then you are saying, no, you cannot be given, you are not proficient in local language. So these are the things, my lord, these people are behaving. Now, can your lordship comprehend that these people will give me any sort of justice? And this man will be, my lord, will be overreached by that time. Therefore, it's a very, very short matter where your lordship will find I have got a sufficient experience. Forget about whether I get any marks while I was pursuing my research studies. If I do not get also, it's not affecting me because I am having sufficient experience, teaching experience after qualified teacher as UGC teacher in 2008. Now, these are the simple things, my lord, your lordship will consider and see whether I am eligible to get 5 marks as MPhil or 5 marks as teaching experience. No need of sending back to those people who will do nothing. Again, I will have to come before your lordship. And the area of, my lord, adjudication is very, very simple. My lord, this is my submission.
So far as your MPhil is concerned, that we are clear of.
My lord.
But the teaching experience, after you obtained your MPhil in 2008, then you continued with your PhD.
My lord, PhD has come in the 2014. But the moment I have become UGC qualified teacher, that teaching experience will be counted. Your lordship has seen the 1st January 2007.
Yes.
They have said I become qualified teacher when I get my MPhil degree. So if I do not have the PhD also, as a teaching experience as a UGC qualified teacher, I am having sufficient number of years, 9 years of experience.
Go to page 84.
My lord. Page 84, yes. The lordship may turn to 86, my lord. Teaching experience 5 marks. 1 mark for each completed year of service in an affiliated government college. Maximum 5 marks. My college is affiliated. And your lordship has seen there are 3 professors by getting MPhil degree through distance mode in the year 2009, 2008. They have been accommodated there in the same college. And the government did not find any fault with them. They also got marks in the MPhil as well as my lord teaching experience.
Which document was it that which prescribed that when you are doing MPhil, that period will not be counted for teaching?
Melodious.
Page 127.
Your lordship may come to page 127, my lord. It is not, if it is not given also, it's not affecting me. 3.9.0. The period of time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the teaching positions. Before that, your lordship may see page 108 also. Page 108, my lord. This is the letter dated 1st March 2016. The issue regarding counting of the period of active service spent on pursuing a PhD was considered by the UGC in its 512th meeting held on 4th February 2016. The clarification of University Grant Commission is as follows. The period of active service spent on pursuing research degree, that is, for acquiring PhD degree simultaneously without taking any kind of leave, may be counted as teaching experience for the purpose of direct recruitment. Now, this is a direct recruitment of assistant professor. I am not much on all these things because I have already acquired that qualification as MPhil teacher. Therefore, if your lordship do not go into that, if I am not given any marks on that, it's not affecting me at all. Because of this, my lord, this clarification has made emphatically clear that if I spend the time without taking any leave and I give the teaching assignment simultaneously when I do my research studies, then that period will be counted. But I am not arguing why. Because why should I argue that when I am having already qualifying marks, 9 years of as a qualified teacher, I have taught in the college and I have been teaching. So this area I need not travel, my lord. So therefore, my lord, it's all admitted thing. And your lordship, this is a very, very simple area whether I am eligible to get 5 marks in teaching experience. So I think your lordship can adjudicate that without sending it back. And if I, my lord, after hearing them, if I want to reply, I will reply.
May it please your lordship, my lord. 1 minute. Yes, please.
Yeah, my lord, I'm appearing for the University Grants Commission, respondent number 12. My lord, the issues are really in a very narrow campus. What my respectful submission would be, my lord.
Respondent number?
12, University Grants Commission. My lord, my argument or my proposition, what I would like to propose before lordship, my lord, very confined to the whether the MPhil degree is a required qualification for appointment as a assistant professor in a college. First question. Second, if it is a degree obtained through distance movement off campus study center, whether this is a valid degree. If you are not possessing a valid degree, then the teaching experience after getting that degree is not countable. It's a clear and settled law. First of all, my lord, am I clear, my lord? First of all, MPhil has never been a required qualification for appointment to the post of assistant professor in any college and universities. Therefore, the required qualification is NET or SLATE or PhD. Either NET or SLATE or PhD. MPhil has never been a required qualification. Therefore, the period, even if my learned senior friend said that this is a valid degree, I'll go to that later on. Even if we presume for a moment that this is a valid degree, if he obtains the degree in September 2008, from 2008 to 2017 or 14, when this advertisement were issued, this period cannot be treated as cannot be treated as a teaching experience in as much as this is not a valid degree. Because this is not the person concerned did not possess the required qualification to be appointed under the UGC norms. Had he obtained the required qualification, suppose he's a NET person, he passed NET, and he also have MPhil degree, then this argument could have placed the
That provision.
Pardon me.
Where's that provision?
Because everywhere it is there, my lord. From 2001, sorry, 1998. From 1998, NET is a required qualification. From 1998, and at the relevant point of time, the I believe he appointed. So he was appointed in 2005. So the required notification of UGC would be 2004 or 2002. The requirement of NET is since 1998. 1 minute, I'll show to you. And if I can read it from 2010 also, this is there, my lord. Same thing the UGC is following, my lord, since 1998. Sometimes there may be a little bit of changes, but required qualification is same for all. Assistant Professor Miller, good academic record as defined by the concerned universities with at least 55% marks or an equivalent degree in grade in a point scale, whether grading system is followed at the master's degree level in a relevant subject from an Indian university or an equivalent degree from an accredited foreign university. Besides fulfilling the above qualification, the candidate must have cleared the national eligibility test, that is NET, conducted by the UGC, CSIR, or similar test accredited by the UGC like SLATE or SATE, notwithstanding anything contained in subclauses 1 and 2 to clause so and so, candidates who are.
You're reading from where? You're reading from.
I'm reading from a regulation 2010. This is same with 1998. I'll show to 1998 also. By the time it brings by my friend Miller, I just would like to show that MPhil has never been a required qualification for the post of assistant professor. Therefore, if he is not acquiring the required qualification for a particular post, even if he is working there, the teaching experience for that particular period until he obtained the required qualification cannot be counted. He acquired required qualification only in the year 2014 or 17 when he obtained the PhD degree. So from PhD degree to the issuance of the advertisement, this period may be counted as a teaching experience. This is clear. Number two, coming to the validity of his MPhil degree. For the moment, presume it either way, my lord, and vice versa, I'm arguing. Even if it is a required, the MPhil is a required qualification, suppose, then my lord will testify whether this degree is valid or not. There is a judgment passed by this honorable court in division bench. There is also UGC was a party, my lord. It's not a reporter's judgment, but it was passed by a division bench of this court, my lord. My lord, my learned senior friend has very fairly submitted that this is a distance mode degree. Degree after degree distance offered to distance mode, my lord, MPhil and PhD prior to 2009, if it was offered beyond the territorial jurisdiction of that particular university, is invalid. This has been clarified by Professor Jashpal, judgment of Professor Jashpal. My lord, may I kindly read? May I read if your lordship allows me, my lord? If I can take your lordship to page, my lord, 6 of that judgment, paragraph 2. Got it. Yeah. The issue that was brought up for adjudication before the writ court is that an advertisement was issued on 19/6/2016 for filling up a post of principals of various higher secondary schools. In this section, in this selection, the appellants respondents were selected as first nominee and appointed as principal. It is admitted case that the appellant Sri Ashit Baran Paul had obtained MA degree from Agartala Center of Madurai Kamraj University. This is most important. Here it is, Vinayaka Mission University. Now, my lord, my senior friend must show to this honorable court. I demand that where was the examination center and the study center of his degree? He has never gone to Madurai Kamraj University for taking admission and giving examination. He has never gone. That I can challenge me. None of the distance education's mode degree obtained by any person in Assam, at least, that we have come across in the last 10-15 years. My lord, nobody has gone to that college or that university for that matter, for giving the examination. Thus, their degrees are invalid. This is the same case I'm showing you. How this honorable court has dealt with. The issue that was brought up for adjudication before this court, writ court, is that an advertisement was issued on 19/6/2016 for filling up a post of principal of various higher secondary school. In the selection, the appellants were selected as first nominee and appointed as principal. It is admitted case that the appellant Sri Ashit Baran Paul had obtained MA degree from Agartala Center of Madurai Kamraj University. It is also an admitted fact that the aforesaid degree obtained by the appellant is from an off-campus study center. This is kindly unremarked, my lord. Tripura state, situated outside the state of Tamil Nadu. Likewise, appellant Sri Bijannath was appointed as principal. However, had passed MA degree from Sam Higginbottom University Study Center at Silchar. However, the university for the Sage Study Center was located at Allahabad, Uttar Pradesh. The respondents raise a plea that a person who has obtained degree from such a study center operating outside the state where university is located would not be a valid degree for the purposes of considering eligibility for the post of principal. Learned single judge Vaidhi impugned judgment held that the selection is liable to be interfered with on the ground that the incumbents, the appellants before us, do not possess valid postgraduate degrees, which is an essential requirement under the rules. Consequently, their appointments as principal in the schools in question were set aside, and the respondents were given liberty to fill up the post from the panel of selected candidates in accordance with which law. For considering whether a degree is recognized or not, it would be most appropriate to refer to the affidavit filed on behalf of the UGC in both the petitions. The UGC brought out the facts and the legal position that UGC has never at any point of time granted the above named university to open study centers outside the states where they were located. For the purpose of exact reference, we extract herein below paragraph 8 and 9 of the counter affidavit filed by so holding the post of education officer in the University Grants Commission, New Delhi, on behalf of the respondent number 8. The said paragraphs reads as under. It is respectfully submitted that the basic issue that leading to this filing of the instant writ petition is that the master degree in economics obtained by the respondent number 4, Sri Ashit Baran Paul, from the Madurai Kamraj University, Tamil Nadu, under distance mode from an off-campus center in Tripura is claimed to be invalid. Thus, cannot be used for any purpose. This honorable court at this juncture implemented the University Grants Commission as a party respondent and asked the UGC to clarify the aforesaid issue. The reply of the University Grants Commission in this point are as follows. Madurai Kamraj University, Madurai, Tamil Nadu, is a state university. It can operate within its state only. The university is not authorized to open study center, off-campus center beyond the territorial jurisdiction of the state. The University Grants Commission, after the judgment passed by the Honorable Supreme Court in Yaspal case, reported in 2005, 5 SCC 420, has clarified the issue of territorial jurisdiction and opening of study center from time to time. However, it is on records that the University Grants Commission and erstwhile Distance Education Council under the IGNO has time and again issued various notifications in this regard. Be it stated herein that the UGC has never at any point of time granted permission to Madurai Kamraj University, Madurai, Tamil Nadu to open any study center and or off-campus study center outside the state of Tamil Nadu. Hence, it is categorically stated that the respondent number 4, who has obtained a degree through an off-campus center outside the state of Tamil Nadu, is not recognized by UGC. Moreover, Madurai Kamraj University cannot have examination center in Tripura or erstwhile examination center in Tripura except in Tamil Nadu. Therefore, appearing the examination in Tripura, which was held by the said university, cannot be held good. That the answering respondent on behalf of the UGC begs to state that it is not a case that the UGC had issued only one directives, that is on so-and-so date, for what, and for that matter, notice, notification, etc., as regards functioning of the universities which are imparting education in distance or open learning mode. It is utmost necessary at this point to make a mention of the notification issued from time to time in this regard. UGC policies on territorial jurisdictions, study centers, off-campus, etc., has been elaborated in various University Grants Commission's letters. The public notice dated 27 June 2013 was only reiteration of earlier policy of UGC on territorial jurisdiction of a university. The UGC letter dated 9/8/2001 directed all universities as under. The universities can conduct courses through its own departments, its constituent college, and or through its affiliated institutions. There is, however, no provision for leaving it to private institution for conducting course leading to award of its degrees. As per recent UGC guidelines, the universities are permitted to impart education and award its degree through their own campus located elsewhere in the country or even their own offshore campuses with the approval of the UGC. Looking into the widespread or franchising the university education through the private institution, the UGC has decided that any university which proposed to enter into collaboration with any private institution would be required to take prior approval of the UGC. The Commission has also decided that no university should be permitted to go for off-campus private educational franchise leading to the award of its degrees. Accordingly, all the universities are being directed to stop franchising their degree education through private agencies with immediate effect. On similar lines, reply was filed in the writ petition, which is subject to matter of the writ people number so-and-so. Considering the stand of the UGC to the effect that in terms of judgment rendered in Honorable Supreme Court in Professor Yaspal case, the issue of territorial jurisdiction and opening study center has been clarified by the UGC. UGC from time to time has issued various circulars and directions beginning 2001. The said UGC circular has been extracted in paragraph 9(1) above, which demonstrate that not only the appellants were not eligible to compete for the post of principal because they lacked the basic qualification, not having passed MA, MSc from UGC recognized university, but also the said circulars and notification have been circulated repeatedly since 2001. It stands demonstrated that the appellants in the two appeals obtained degrees from study centers located outside the state where the concerned universities were located. Hence, the said degrees cannot be said to have been issued by the UGC recognized universities. They have to show either before this honorable court or before the director, if it is remanded back, that their degrees are valid and they went to give their examination in that particular universities. My lord, in my experience, in my respectful submission, they appeared in the examination in Assam, somewhere in Assam, under an occupied study centers. Therefore, my lord, in my respectful submission, this is not a valid degree. And if it is not a valid degree, then the experience till he acquires the degree of PhD shall not be counted because he is not a qualified teacher to be impart higher education. This is my submission. And next, my lord, the 1st March 2016 letter at page number 108 issued by the University Grants Commission. My lord, we'll see, my lord, 1st March 2016, where it is said that the period of active service spent on pursuing research degree, that is for acquiring PhD degree, simultaneously with taking any kind of leave, may be counted as teaching experience for the purpose of direct recruitment to the post of associate professor and above. My lord will appreciate this letter for two reasons does not hold the field or cannot hold the field, because it says about the post of associate professor and above, not for the assistant professor. Number one. And number two, after 1st March 2016, my lord will come to page 125 now. This letter, the clarification given by the UGC in 2016 letter dated 1st March 2016 is redundant because of two reasons. In vis-a-vis this particular case, because this is a case for assistant professor, not for the associate professor. It says will not associate professor and above. Number one. Number two, 2016 regulation came on 4th May 2016 after 1st March. Therefore, the finding 120 the regulation at page 127.3.9.0 is relevant, not this letter. Because this is just clarificatory. This letter was of clarificatory nature.
Which letter?
This 1st March 2016 at page 105.
What about 104? Annexure 22.
I'm coming to. Oh,
104A.
There is no 104A, my lord, and I cannot read 104.
104
Poriban one.
Except 22.
The Poriban one is
Type 1 to Quran.
type diya nahi.
104.
But I cannot read this because the type copy was not given to us.
My lord, he can read from my copy.
Thank you. From Thiru so and so to the all universities under the control of Higher Education Department. Higher Education Department offering MPhil PhD courses to distance education by universities dispense with effect from 2007 to order issued. Well, this is a order issued by the state of Tamil Nadu. Well, we are as University Grants Commission, we are not not known to or not. I'm not instructed to comment upon this. In the Vice Chancellor's meeting held on so and so under the chairmanship of the Honorable Minister of Higher Education, the issue relating to the dispensing with the system of offering PhD courses MPhil through distance education was discussed in detail. The government, after careful consideration, direct all the universities under the aegis of Higher Department that MPhil PhD courses should not be offered through distance education from the academic year 2008, and they should be offered only in regular system. After even in conformity with this, my lord, the UGC regulation, MPhil PhD regulation 2009 came with effect from 9 July 2009. That also categorically said that PhD and MPhil cannot be given through distance mode. Even if we presume for a moment that the distance education, the MPhil degree provided through distance mode prior to 2009, then also they have to comply with the other norms of the University Grants Commission's regulation that it is to be within the territory of that university. And this has been held by this honorable court in a division bench, coordinate bench of this court, honorable court. That if you have gone beyond your territory and you have rendered, you have obtained the degree through a distance, off-campus study centers, then it is invalid. So, my lord, this is a question of disputed questions of fact, whether they are, or he obtained a degree here in Assam or he went to Binayak Mission University. But my experience says it is not. There were mushroom growing of franchising degree educations to various private institutions. Various. Now it has come down. Now it has come down after the University Grants Commission's regulations. But in 2006-07, it was mushrooming. And he obtained PhD degree. When he obtained PhD degree, then only he became the eligible teacher under the UGC regulation. This is my respectful submission. Lordship will consider the other aspect. To judgment, Lordship must go through. My friend will definitely apprise your Lordship.
Now, what do you say on para 28C, page 188 of the judgment?
While examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science. My MPhil degree too, in my respectful submission, is never been a required qualification. So
whatever is, carry on.
Pardon?
Carry on with it.
Yes, my lord. Computer science in the concerned college, without commenting on validity or otherwise of the degree, as the validity of degree is not under challenge or question. But why? Who will challenge the validity? Well, he had the learned single judge.
This was not the ground that you took before the learned single judge, correct?
My lord, that is why learned single judge, since it is a disputed questions of fact, learned single judge, my lord, has referred
the one which you are taking today,
my lord,
that was not taken before the learned single judge. That's why this learned single judge.
Yes,
might make his comment.
Well, he said, my lord, it was the director of higher education who has to show it. If they have taken this as a ground, my lord, I don't know. My friend will address.
You were also there in the learned single judge.
No, I was not there.
You were not there.
Oh, sorry. I was there, sorry. I was there, but we did not file affidavit, my lord. We did not get the time.
File affidavit. Then that is no grounds were taken. The grounds which you are taking today, those grounds were not taken before the learned single.
No, yes, if that is, my lord, then from that aspect, yes, my lord. But my lord, this is a disputed questions of fact. So that is why learned single judge referred this matter to the authority. (98 to 100). 98.
Yes.
Actually, my friend will address the other issues. my lord.
The issue is this, if you have not taken any grounds, this ground before the single judge,
Yes, ma'am.
can you take that ground today?
My lord, this will be, in my respectful submission, this will be a technical one. But even if your lordship would like to act upon this thing, my lord, my friend will show that whether this ground was taken in Leonard Single Judge or not. But my role is very limited. And yes, I wanted to show, my lord, in my,
But where the documents?
yes, my friend. My lord, it's all along, never, MPhil has never been a required qualification.
Where is that?
Yes, ma'am. 1990. Earlier it was called lecturer. Earlier the terminology, the post was called lecturer. Now it is redesignated as assistant professor. 4 point.
You don't have copies.
We'll provide it. Actually, the whole bunch of regulations I always used to carry today. It is not.
I will provide.
Which one?
4.0 lecturer.
4.40.
My lord, the admit card of their examination for MPhil, admit card issued by the university for MPhil examination will reveal the whole truth. The admit card will be inclusive of the name of this examination center. They have not annexed it anywhere.
But page 86.
Yes, ma'am.
This is with regard to the guideline
Guideline
for the post of assistant officer. Correct. Page 84.
And this is the notification, my lord, issued by the Higher Education Department, government of Assam.
State provides for MPhil, page 86.
Pardon me, lord, in page 80.
Research performance.
Yes.
Page 86 at Roman 2.
Which? No, my lord, this is for giving marks in for giving marks for interview.
This is what the appellant is.
That is what, my lord. But for that they have to have a valid degree. Until it is proved this is a valid degree, this is nothing but a piece of paper. This is a pattern, it's a guidelines to provide marks, distribution of marks. This is not a required qualification. Required qualification is that what I have given.
But what about a single just observation that
Single just said that I am not deciding the validity or otherwise of the degree.
because it's not under challenge, that you could have challenged it.
No, there is no occasion to challenge by the department, I suppose, because had it been said by the learned single judge that this is a valid degree, then perhaps the state would have filed an appeal. Learned judge has not commented upon it. Learned single judge said we are not commenting upon the validity or otherwise of the degree. Hence, it is kept open for the authority to decide because it includes the disputed questions of fact. It involves. But my friend will let this. Well, may I take your lordship leave? I'm not feeling well satisfied.
Your respondent.
I'm clear.
But I'll just reply what my learned friend has said.
Hmm.
The lordship will find in the learned single judge, he was not even present. Not to file about the filing of affidavit.
No, my junior was there. I was represented by my.
No, I'm not saying all that. It is from the learned single judge. What I'll just read out the single line. Lord, you will not say anything now coming here, even without filing an affidavit, you will say so many things. Now, your lordship kindly see at page 171. First para, none appears for the respondent number 3 to 11 on call.
I was respondent number 12. I was represented by MSJ Gayon, learned counsel for respondent number 12.
No, they did not file any affidavit.
That's
The
the
lordship
thing.
will not file
That's
any
what I
affidavit.
agreed. That is, I have agreed and I have said
Now,
before the
now
court.
what my learned
Being
friend
an officer
said,
of the court, I have addressed the law point, my lord. I am not on the facts.
No,
So
no,
far
no.
as law point is concerned, I have addressed this honorable court. If lordship pleases to agree to accept my arguments without even filing an affidavit, then well and good. Otherwise, lordship will reject. So since you have not filed affidavit in law court, single judge, so we are not accepting your argument.
even my lord, my learned friend has said, I have appeared examination in MPhil in Assam. It is he saying, he said, from my experience, I am saying. Now, the record, it is before the learned single judge. I have shown the paper that I sat in the examination Annamalai Nagar in their campus. That is there on the record, my lord. Now, should we say all these things unnecessarily?
Which record?
It is just now I have handed over. It is before the I have produced these documents, my lord. Rajiv Das, roll number so and so, course MPhil, Venu Department of Computer Science, Annamalai Nagar. The factually we must be correct before the court. So therefore, my lord, we should be careful when we submit something.
No, my lord, I'm not misleading or something wrong, my lord.
I'm not saying.
What I have said that from my experience, I have said that this is a rampant things. This is going on everywhere in northeastern states or even in North India and South India. Enter India, pan India is a rampant, my lord. This is the practice. Now it has been stopped.
Everything should not be with jaundice eyes everywhere.
You are referring to attendance certificate.
My lord, this paper, my lord, just few minutes back, I just provided to your lordships. I can send it to your lordship now also. Last but one, your lordship may find.
Includes the ID.
Yes, everything is there, his roll number, everything, and the place, the venue is Annamalai Nagar. Well, my learned friend said I sat in the examination in Assam. I don't know from where he got that.
No, I say it from my experience. I have not seen the record.
Experience.
These are the disputed cases of fact, my lord.
But tell about this case.
Is it recognized university?
Yes, yes. My lord, this is the third.
UGC and the government of Assam.
Yes, they have accepted and I have shown.
You should have the MPhil, which is recognized by the UGC.
No, it is recognized by the UGC.
Government of Assam.
Yes, it is.
Only you are entitled as per page 86.
Your lordship is very right. And this is recognized by government of Assam. That's
Just
why.
having a MPhil will not do.
No, my lord, your lordship will say with the MPhil degree, your lordship has seen in the government of Assam accepted so many appointments. And being satisfied all these things on record, the learned single judge has passed an order. And my lord, my learned friend has said the learned single judge did not say that. I'll read once again for him. While examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science, the concerned college, without commenting or validating or otherwise of the degree, as the validity of degree is not in challenge. Now, the authority also has not been given that scope to scrutinize whether it is valid or not, because they did not argue all that.
So you set your exam from this Annamalai
University, my lord, yes. And this is the melody in Asia. This is the third largest university, not only in India. And that's why UGC and
So are you saying that you took your MPhil not from off campus university?
it's a distance mode, my lord, admittedly.
Distance mode, but
Yes, yes.
not off campus?
No, 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 no. I went there for examination. This is the, my lord, your lordship has seen. This is the paper. And the learned single judge also being satisfied with all that, my lord, this finding was given. It is not just on the air. And they did not say anything at that period of time. Their counsel was present in the court. She has accepted very well. She did not argue anything on that, my lord.
So this distance mode also has also been discontinued. From
Now it is discontinued. Now it is
2007 to
No, what
2000.
my respectful submission is, my lord, lordship, my lord, my senior friend has interpreted it differently. My respectful submission was, my lord, if it is an off-campus study center, he cannot have an admission here without a study center. If it is an off-campus study center, then it is invalid. He took admission directly under the university through postal things and went there for appearance in the examination, then it is a valid one.
That's what is happening here.
No, but not these things, we are not privy to those documents. How can we comment on that?
without any
No,
pleading.
The part of those
They do
things,
not have
those-
any pleading
My
in
lord,
this case.
these documents are for the first time placed before it is.
It was before the single judgment. He was not there. Now how
No.
can she
What
say?
Do you have an
That's not a part of pleading.
Yes,
my lord.
yes.
Just showing to the honorable court does not make a part of pleading.
No, before the single judge, he was not there. We argued it. The whole day the argument was
Even
there.
even if it is not made, they have not adduced as a by filing an additional affidavit.
My lord, it
It's a
was,
writ petition, it can be
it was
done.
their counsel was there. The counsel did not say anything. The counsel
My lord,
accepted
my,
all this.
my limited role in this
We
particular
have
case
given
is
the
to
copy
show
to
the
them
law
also.
points, so that the courts are not misguided. That is what.
No, the issue now is that you've come up with that off-campus center,
Yes,
correct?
my lord.
Now the appellant is proving that he did his examination from Annamalai.
My lord, to verify whether this is a document bearing the veracity, to find out the veracity of this document, we are not privy to it.
He's giving a copy.
But
He-
then how
he
can I
ordered-
now say that I have to take instruction on this, that this is right?
Doesn't matter. Give him a copy at least. Let us. be
My lord,
clear about this
very unfortunate part, my lord, before the single judge, when the matter was argued, the copy was given to their counsel. They did not say anything. They accepted it. Now, without filing anything before your lordship, there is no affidavit
So
even.
lordship may discard my argument on that count, my lord.
Now
Lordship
he
pleases.
says so many things.
That is what I am saying. If only because that I was not finding an affidavit learned before the learned single judge, lordship doesn't want to hear me. Okay, fine. I am not forcing.
His lordship is hearing you very nicely. Why should
That
you
is
blame?
that is what my learned senior friend is pushing, that he should not be heard.
Blaming the judge
And
is
should
a
not be
very
heard
obvious
because
thing.
I did not find an affidavit. Fine. No issue. Nothing goes from me. But being an officer of the court, even if I am not a party to this proceeding, I can come and say to the honorable court, my lord, no, this is the law position. Being an officer of the court. That is what we have learned from him.
No, Mr. Chamua, what we're trying to qualify, what we're trying to see is whether he did his MPhil from North campus and
I have to take instructions.
or from Annamalai University.
I have to take instructions on
As far
this.
as his admit card is concerned,
Yes.
this is an admit card, correct? He did it from Annamalai University. And he's making a submission that he did not do his MPhil from an off-campus center.
Yes.
He did it from Annamalai.
Give me some time, I will come up with instructions.
Okay, Gogo, you can do that.
Yes, my lord. In the meantime, my friend will, my lord. But lordship has to give me some time because
Doesn't matter. Let us hear Gogo.
My lord, fine.
Since that we have heard for quite some time,
My lord.
let us finish it.
I'm
Yes, Gogo.
with pleasure, Lordship. I am starting the point where controversy arises, Lordship. It's our clear stand before the Honorable Single Judge that the distance mode, the government of Assam is not recognized, which has fallen from my lord that whether it
You are
was
appearing for respondents?
Higher Education Department, Lordship.
Respondent 2%.
I am for Higher Education Department, Lordship. Respondent number 1 and 2, Lordship. My lord, may I kindly come to page 129, Lordship. It's a affidavit filed by Director of Higher Education of Assam before the Honorable Single Judge, Lordship. So my lord, may I kindly come to page 130, Lordship. Paragraph 6, if Lordship permit, I can read it.
Yes.
Paragraph 6, Lordship. That with regard to the statement made in paragraph so and so of the writ petition, the deponent states that it is a matter of record and put to the writ petitioner states proof to thereof that denies everything which is beyond the records. It is stated that writ petitioner obtained MPhil degree on 29/9/2008 through distance mode from Annamalai University, Chennai, while he was serving as assistant professor in the Department of Computer Science and Application in Karimganj College, Karimganj. Further, as per government office memorandum so and so, it is clearly reveals that writ petitioner is not eligible for getting the marks of MPhil degree since he has acquired the said degree through distance mode and is against the decision of the government as well as the notification made in this regard.
Let us see this 9/7/2013.
9/7/22 probably, Lordship, it was not annexed, Lordship.
It was next, we just read some time back.
Lordship. 9/7/22.
Page 141.
Page 141,
We have not annexed it, Lordship.
whatever it is.
Lordship. 141. Functioning of campus centers, study centers open on the university outside the territorial jurisdiction of the state, Lordship. On the basis of that, we have stated that, Lordship, this directorate has not accepted the degree which was obtained through the distance education mode, Lordship.
Read it, we'll see.
Government of Assam is aware on the issue of their off-campus centers, study centers, and centers operating through franchisee and open in the state by universities outside the territorial jurisdiction of the university. However, in view of the decision of the Honorable Supreme Court of India in Professor Espal's and other cases, yes, no university can start off-campus centers beyond the territorial jurisdiction of the concerned university as specified. Recently, it has been noticed and reported that there are large number of such off-campus centers in other Indian universities which are functioning in Assam in spite of the Honorable Supreme Court judgment against such off-campus centers, study centers. In view of the approach of Honorable Court judgment, with a view that such off-campus centers which are existing and are violation of the in Supreme Court order, the following directions shall come into effect with immediate effect. The concerned university shall ensure that no off-campus centers, study centers, and the centers operating through franchisee are opened by the universities outside the specific territorial jurisdiction in view of the judgment of the Honorable Supreme Court of India and Professor Espal versus Government of Chhattisgarh. In the case of university, has already stated an off-campus study center violating the Supreme Court's order, and centers are operating through franchisee and state. The same is to be closed immediately. No distance education program shall be started without the prior approval of the Distance Education Council, the Registry Board, or the Distance Education Programs, Lordship. The Director of Higher Education Assam and Director of Technical Assam shall strictly ensure that off-campus study center which are in existence of the state violation Supreme Court's order do not function. The Government of Assam will not recognize any degree diploma as acquired by the student who complete such degrees diplomas from such off-campus centers.
So Google, this is with regard to off-campus centers. It does not say that the distance mode is not
Lordship,
allowed.
no distance education program shall be started without the prior approval of the Distance Education Council. And here the issue is, Lordship, the notice.
This is of 2012.
Lordship.
Correct.
Lordship.
He got his MPhil in
Not required, Lordship.
2004.
In Apex Code in Kumansal Institute of Technology 2007 itself declared, Lordship. So not required, Lordship.
This with regard to off-campus.
Off-campus, Lordship, and distance mode, and Professor Espal 2005 distance mode, Lordship. Not required, Lordship. Not only off-campus, it relates to the distance mode also, Lordship. Professor Espal case, I will place it, Lordship.
Okay.
Already law is well settled by the Honorable Apex Court. So this, if the Government of Assam, whether they issue the notification or not, It is not a fact, lordship. It is not an issue. Law is well settled, lordship, in 2005 itself, lordship. It is no meaning. Today I have said that the issuance of the 2012 notification is no meaning as per a law laid down by the Honorable Apex Court, lordship. Now, lordship, my lord may kindly come to the, this is our clear stand in our affidavit, that we are not accepted the distance education modes, and as per the OM also, lordship, which should be accepted by the government of Assam, lordship. Government of Assam did not accept it, lordship. So he is not entitled for the marks, lordship. That is our stand in the Honorable Single Judge, lordship. Now, lordship, my lord may kindly come to the Honorable Single Judge judgment, lordship. Which starts from, lordship, page 169. So my lord may kindly come to page 172. Page 172. Where?
But in the other colleges, you have awarded him a mark for marks for MP.
Lordship, I will explain it, lordship. If rightly, wrongly, that marks is given, lordship, not a concept of negative equality, lordship.
It's not a question of
the authority, the board,
it's not a question of negative equality.
Otherwise, also, lordship, the board realized that he is not entitled for the marks later on. Then it was not given, lordship.
Then subsequent rejection is on language.
Language part already settled. Language part already settled. There is no dispute. The Honorable Single Judge judgment is there, lordship.
Finally, you have said this because of the less enrollment.
Less enrollment part, lordship has already interfered. Less enrollment part today, no issue. Single Judge already interfered. Then we cannot reject it on the ground of less enrollment. Now, lordship has to decide only one issue. For getting the teaching experience marks, whether he possesses the requisite educational qualification prescribed by the UGC in 2008 or not.
Then what learned single judge has said?
Learned single judge did not decide the issue. Regarding that particular, so I am page 172, lordship. That point I page 172. It is not decided by the learned single judge. Even the issue was not required to be decided by the Honorable Single Judge, lordship, as per the law laid down by the Honorable Apex Court, lordship. Page 172, lordship. The Honorable Single Judge, lordship, framed three moot questions for deciding the issue involved in that particular writ petition, lordship. Paragraph 5, lordship. The points raised by the learned senior counsel for the petitioner is as discussed issue-wise. The issue raised are summarized as follows, lordship. Whether the petitioners awarded lesser marks by not treating time spent for pursuing MPhil and PhD degree as teaching experience. Number 2, lordship, whether the petitioners was legally denied marks despite having MPhil degree, lordship. Then whether the petitioners was awarded lesser marks by way of hostile discrimination on account of language. That part already decided. And regarding B, lordship, regarding issue number B, what is the decision of the Honorable Single Judge, lordship? For that purpose, my lord may kindly come to page 186, lordship. Paragraph 26. This is the findings of the Honorable Single Judge. For the reasons as discussed above, as regards the point of determination number B. B is, lordship, whether the petitioner was illegally denied marks despite having MPhil degree. What is the findings of the Honorable Single Judge, lordship? The court is of the considered opinion that the competent authority in the higher education department should take a call. We refrain from deciding the matter as it involves examining various notifications and OMs of the higher education department of the State University Grants Commission, Indira Gandhi National Open University, and Distance Education Council, and therefore such an examination is left to the higher education department. This is the findings of the Honorable Single Judge in respect of point number B, where it says that there is any violation for not giving the marks to the MPhil degree, then Honorable Single Judge says that it required examination, it required experts' opinion, it requires verification of certain notifications and office memorandum issued by the Government of Assam as well as University Grants Commission. So it is left to the Director of Higher Education higher education to examine it on the basis of it. So that particular issue was not decided by honorable single judge. It is kept open as because it requires the expert opinion. This is the point in respect of lordship issue number B, lordship. Honorable single judge nowhere says that his degree is a valid one. His degree is a valid one, and otherwise also honorable court does not say that. Single judge says that he is not entitled for the MPhil marks or he will be entitled for the MPhil mark. Honorable single judge says that it requires some verification of the certain notifications and guidelines issued by the government of Assam, as well as the UGC, as well as the National Open University. So it requires some expert opinion. Yes, because the court is not an expert in the education matter, educations which is required a clarification from the various source, as per the law laid down by the Honorable Apex Court in the Anand Samas case also. Even Honorable Apex Court says that we are not an expert body. We are not an expert to go to the academic arena. We cannot go to what is the degrees valid or invalid. This is the findings of the Honorable Apex Court in Anand Samas case. I will place it also, Lordship. Honorable Apex Court says that where expert opinion is required, then it should be left to the authority who have examined it, Lordship. And Lordship, regarding that C, page 188.
D and C were decided in 26.
Lordship, 26. 26, that was decided. 26 decided. Now regarding that validity part or invalidity part.
Direction.
That what is the observation of the honorable single judge, Lordship? The honorable single judge says that while examining the matter, it would be open to the state authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in concerned college. It should be read in two parts. Then, Lordship, without commenting on the validity or otherwise of the degree, as the validity of the degree is not under challenge in question. No question, no point it arises to challenge the validity of the degree. As because the OM directly specified that it should be accepted by the government, Lordship. When we not accepted it, then it is not required to go for filing appeal. Even that particular observation is not against the government of Assam, Lordship. It says that while you consider for appointment particular post, you examine it. After examining it, you take a decision. It's not says that you cannot go to examine the degree for MPhil and PhD, Lordship. Honorable single judge nowhere bar the Department of Higher Education Department that you cannot examine it, you cannot verify it, Lordship.
It's not an acceptance or something like that.
Lordship.
Government of Assam approved university.
Approved university.
It's not your,
no, we are not
authority rejecting or.
We are not approved that.
No, it has to be approved. Government of Assam, it has to be approved university.
Is to be approved university, but the degree where he obtained the degree, it is not a approved university by the government of Assam, Lordship.
This anomaly,
Lordship.
it is not approved.
Not approved by the government of Assam, Lordship.
We don't think so.
It is not approved by the government of Assam in respect of distance education, Lordship.
So far as distance education
is concerned, Lordship, we are not accepting the degree.
Regular courses, sir.
Regular courses, he is
courses is an approved university.
It is a approved university of the UGC, Lordship. It is not a university that XYZ. It's a renowned university, Lordship. We cannot say that, Lordship, this university is not a recognized.
Requirement is too. UGC recognized. Government of Assam
as well as
approved university.
As well as government of Assam approved university. There is in the approved university list.
Approved university denotes something other than what you are saying, accepting, not accepting.
Approved university list, the Annamala University is not there, Lordship.
You must be aware of how this university.
How this university is functioning. That's why, Lordship, there so many judgments come from the Honorable Apex Court also, Lordship. Recent judgments also come from the state of Kerala also, Lordship.
No. You have not got the point.
Lordship.
You are saying Annamala University is approved by the UGC.
Lordship. No
the-
question,
The
Lordship.
condition factor says and approved by the government.
Approved by the government of Assam,
Is
Lordship.
Annamalai University approved by the government? of Assam?
Annamalai University is not a university who is approved list of the government of Assam, Lordship. There is no any list, Lordship.
So as
Today I have not, Lordship. There is no any list, Lordship.
so
Regarding
there's no list approved university of the government of Assam.
approved university list is there.
Obviously, the university of the state
University
will be there.
There is a
There will be a
there
list
is
of
a
approved
there is
university.
a 23 university operating in the state of Assam. These are the approved university of the government of Assam, Lordship.
So other than the state universities,
State universities, Lordships, the degree
you don't
which
have the list of approved university. I don't think so.
Lordship, the degree where they have obtained, Lordship.
No, Gogo, you're not getting.
No, Lord, I got the point,
Do you
Lordship.
have the list of approved universities?
We have the list of approved university of the state of Assam, where consists of 23rd university, including the Sankodev University of Science, University of Medical Science, Lordship. Here, Lordship, the degree obtained from the outside of Assam, Lordship, when it comes to the consideration before the authority, then it was sent to the concerned university for verification, Lordship. Say one obtained degree, master's degree from University of Pune. Lordship has also gone to several cases, Lordship, when Lordship single bench Lordship is taken the education. Then Lordship regulations matters have come. The persons who has obtained outside the Assam, they are left out. For that persons, we have sent the documents for verification to that particular university.
That means in that case,
Lordship.
suppose a person obtained a PhD degree
Lordship,
from
Lord.
other university,
Then it
other
will-
than a state,
Lordship. Then it will send to the particular university for Lordship verification.
then you will approve.
Then we will approve, Lordship. Some Lordship, already some result is coming, Lordship.
Reverse.
Lordship.
Government will take a decision which university has to
Like,
approve.
we,
There will be list.
Lordship, we cannot,
Recognize, not recognize. that
we
will be
cannot, Lordship,
not
the
only.
university which was recognized by the UGC, the state authority cannot deny them that they are not a valid university, Lordship. It's a simple fact, Lordship. The university which was recognized by the UGC, Lordship.
But see, read the page 86.
86, I have read, Lordship, where
What it
it
said.
says that it's to be approved by the state, Lordship.
No.
It should be, the degree should,
It's a government of Assam approved university.
Government of Assam approved university, if government of Assam approved university, Lordship,
First one will be UGC recognized
and then
government of Assam approved university.
then second part is the two parts. First one in UGC recognized, second part is government of Assam recognized. Then Lordship, it is limited only 23 universities.
So unless you refer to the whether it is recognized by the approved university or not, how can the appointing authority or the selection committee
Approved university,
accept, not accept, how you can decide that?
approved university list is there, 23rd University of the State of Assam, and other degree which is obtained through various universities outside the state. If the proposal is come for appointment, Lordship, say selection is made in favor of the petitioners, Lordship, then a proposal come along with all the relevant documents. The original file is sent by the GB, Lordship. Then that particular document was sent to the particular university for proof of authentication, Lordship. Otherwise, Lordship, the university which is recognized by the UGC, Lordship, the state authority cannot, Lordship, deny it, Lordship. Yes, because, Lordship, it's a central subject. It's a union list.
Can you show any material that this appeal degree by the appellant, since it's not been recognized, therefore mark has not been allotted? So what? Any document?
It is an admitted fact that, Lordship, it's a distance mode. We are not accepting the degree of distance mode. It is a case of the petitioner, Lordship. It's obtained through distance mode. We are not accepting the distance mode. In our affidavit, we are categorically
In the
listed.
affidavit, you must understand that.
Lordship,
So as some material
Lordship,
that his case has been rejected and marks was not awarded
Lordship.
because it is not a recognized, degree. So what?
It is regarding degree, Lordship, not the, it is not the university, Lordship. It is a degree, Lordship. It is a degree obtained through distance mode, Lordship.
Do we have material or not?
We have, Lordship.
So
I can
so-
place it, Lordship, fix any other day. I can place
No.
it. I can.
We have
Okay. Or even today hard also, Lordship.
to-
Today, if Lordship hard, Lordship, without placing the documents, I will on the point of law point, I will
No, you have argued, you have filed the affidavit,
Lordship.
you are relying on affidavit in a
Lordship.
single judge.
Lordship.
On that basis, it's an intercourt appeal.
Lordship. That's why I will place it. Second half, Lordship. I will place it. Only the one, Lordship. I will place it.
From the document, from the
record.
From morning we're hearing this.
I am not seeking time, Lordship. From the record, I will argue, Lordship. If Lordship accept it, if Lordship deny it, it's up to Lordship. It is my duty to point out what is the case before your Lordship. It is my only duty. I'm not in favor of him. I'm not in against him. I'm not representing the department to Lordship, oppose him, Lordship. I'm here to assist the Honorable Court in the two facts, Lordship.
No, that's why we're saying show
That's
us the
why
materials.
That's why I will place all the relevant UGC guidelines and others. So this is the documents, Lordship. I will place everything.
F2.
F2, even today, if Lordship continue, I can continue also, Lordship. At that moment also, I can continue, Lordship.
Judgment. From common judgment, do yes. I have called name minus. Deeply obligement. 7th of December, day. December.
Wait, please, Lordship. Before lunch, Lordship, one question was raised, Lordship. The degree regarding MPhil degree, Lordship, whether it is accepted by the authority or not, Lordship. Now, Lordship, from the document itself, Lordship, the mood of offering that particular degree. If that mood is, Lordship, there, as per the Honorable Appeals Court judgment, whether it is acceptable or not, Lordship, regarding MPhil degree. So, for that purpose, my Lord may kindly come to page 88, Lordship. Page 88, Lordship. Here, Lordship, petitioner sought certain information from the Lordship Annamala University, which they have accordingly replied, Lordship. If my Lord permit, I can read it, Lordship. Certain information from Annamala University requested under the Right to Information Act 2005 replies furnished, Lordship. Your letter dated so and so. With reference to the letter cited, I am to inform you that the following details furnished below. The Annamala University is recognized by the UGC and Distance Education Council, New Delhi. Annamala University is one of the universities recognized by the University Grants Commission for the purpose of its grants. The degrees diploma awarded by the Annamala University, which has been established by an act of the state, is then automatically recognized for the purpose of employment under central state government as per a letter dated so and so, Lordship. Then, my Lord, next page. According to DEX officer, Ministry of Human Resource Development, Government of India, the degrees diplomas awarded by the university established by an act of parliament or state legislature institution deemed to be universities under Section 3 of the UGC Act 1956 and institutions of national importance declared under the Act of Parliament is then automatically recognized for the purpose of employment under the central government. Letter dated so and so, Lordship. Now, Lordship may kindly come to that, Lordship. Here. The Distance Education Council, New Delhi has approved all the programs offered to Distance Directorate of Distance Education, Annamala University, by letter dated so and so. Then, my Lord, the course of study is off-campus mode. My Lord may kindly mark it. It's a reply of the Annamala University, Lordship. It's a document annexed by the petitioner, Lordship. It's a document issued by the university from where, Lordship, he had obtained the, Lordship, MPhil degree. The document reflects that, Lordship, the course of study is off-campus mode, Lordship. The university itself clarifies, Lordship. The distance education mode is a off-campus mode. If it is a off-campus mode, Lordship, whether it is permissible as per the Honorable Appeals Court judgment, Lordship, it's admitted fact that the degree which was offered to the petitioner through a distance mode, Lordship, It's a off-campus board, Lordship.
Let us see the judgment.
Lordship. Professor Yespal, that day I have forwarded the copy. Again, today also I have forwarded, Lordship. I am relying, Lordship, paragraph 33, 38, 33, 38, 39, 46, 47, and 60, Lordship. Starts from 33, Lordship. It's in internal page 25, Lordship. So it's in page 444, Lordship. 444, Lordship.
Yeah.
The consistent and settled view of this court, therefore, is that, in spite of incorporation of universities as a legislative head being in the state list, the whole gamut of the university, which will include teaching quality of education being imparted, curriculum, standards of examination and evaluation, and also research activity being carried on, will not come within the purview of the state legislature on account of a specific entry on coordination and determination of standards in institutions for higher education, for research and scientific and technical education being in the union list, for which Parliament alone is competent. It is the responsibility of the Parliament to ensure that proper standards are maintained in institutions for higher education or research throughout the country, and also in uniformity in standards is maintained, Lordship. My Lord, may kindly mark last 3 lines, Lordship. Then, Lordship, 38, Lordship. A degree conferred by a university is a proof of the fact that a person has studied a course of a particular higher level and has successfully passed the examination, certifying his proficiency in the said subject of study to such level. In the case of doctorate degree, it certifies that the holder of the degree has attained a high level of knowledge and study in the subject concerned by doing some original research work. A university degree confers a kind of status upon a person like a graduate or a postgraduate. Those who have done research work and have obtained a PhD, DLit, or DSc degree become entitled to write the word doctor before their names and command certain amounts of respect in society as educated and knowledge persons. That apart, the principal advantage of holding a university degree is in the matter of employment, where a minimum qualification like a graduate, postgraduate, or a professional degree from a recognized institute is prescribed. Even for those who do not want to take up a job and want to remain in a private profession like a doctor or lawyer, registration which the medical council and or bar council is necessary for which purposes a degree of medicine or law, as the case may be, from an institution recognized by the said body is essential. An academic degree is, my Lord, may kindly mark it, therefore a great significance and value for the holder thereof, and goes a long way of shaping his future. The interest of society also requires that the holder of an academic degree must possess a requisite proficiency and expertise in the subject which the degree certifies. Then, Lordship, 39. Mere conferment of degree is not enough. What is necessary is that the degree should be recognized. It is for this purpose that the right to confer degree has been given under Section 22 of the UGC Act only to a university established or incorporated or under a central act, provincial act, or state act, or institutions deemed to be university under Section 3 of an institution specially empowered by an act of parliament to confer a grant of degree. Subsection 3 of the section provides that degree means any such degree as may, with the previous approval of the central government, be specified in this behalf by the commission by notification in the official gazette. The value of importance of such degree which are recognized by government was pointed out by the Constitution bench in so and so, Lordship. Then 46, Lordship. Entry 66, which deals with coordination and determination of the standards in institutions of higher education, or research and scientific and technical institution is the union list, and the parliament alone has the legislative competence to legislate on the said topic. The University Grants Commission Act has been made with reference to entry 66. The Act has been enacted to ensure that there is a coordination and determination of standards in university, which are institutions of higher learning, by a body created by the central government. It is the duty and responsibility of the University Grants Commission, which is established by Section 4 of the UGC Act, to determine the coordination, the standards of teaching curriculum, and also level of examination in various universities in the country. In order to achieve the approached objectives, the role of UGC comes to be threefold. The course of study, its nature and volume, has to be ascertained and determined before the commencement of academic session. Proper standard of teaching cannot be achieved unless there is adequate infrastructural facilities in the campus like classroom, libraries, laboratories, well-equipped teaching staff, or requisite caliber of proper student-teachers ratio. For this purpose, Central University has made a number of rules in exercise of powers conferred by Section 25 of the UGC Act, and the Commission has also made regulation in exercise of power conferred by Section 26 of the UGC Act. To mention a few, the UGC inspections of universities rules so and so, UGC's regulations so and so, regarding the regulations 1991 regarding minimum qualification for appointment of teachers of universities, college, etc. UGC, with the approval of the central government and exercise of power under Section 22(3) of the UGC Act, has issued a schedule of degree which may be awarded by the universities. The Impugn Act, which enables a proposal on paper only to be notified as a university and thereby conferring a power upon the universities under Section 22 of the UGC Act to confer degree, has to effect of complete certifying the functioning of the University Grants Commission. Insofar as these universities are concerned, such incorporation of the universities makes it impossible for the UGC to perform its duties and responsibilities to ensure coordination and determination of standards. In the absence of any campus or other infrastructural facilities, UGC cannot take any measures whatsoever to ensure the proper syllabus, level of teaching standards of examination, and evaluation of academic achievements of the students, or even to ensure that the students have undergone the course of study for the prescribed period before the degree is awarded to them. Then Lordship 47. The internship evaluation of merit of candidates is often required to be done while making selection for some higher or specialized course of the study or in the matter of employment. One of the important functions to the perform by UGC is to coordination and determination of the standards in institutions for higher education, so that some kind of uniformity is maintained in level of teaching and examination, and also award degrees by the various universities. The impugn enactment, however, enable a sponsoring body without having any kind of teaching facilities is to award degree in view of the clause 8 and 9 of Section 3 of the Act. The university can establish only to establish examination center or just to institute degrees, diplomas, certificates, and other academic distinction on the basis of the examination and other method of evaluation anywhere and without any predetermined standards. The possibility that such universities which award degrees without serving its teaching facilities and without imparting any education will do so only for the purpose of making money is writ large. The fact that the amendment made in so and so mandatory to create an endowment funds to ₹2 crores having provisions of 15 acres land have to be challenged by the many universities speak volumes of prepared a project report on the paper. This is not important, Lordship. Then Lordship 60. Lordship. Dr. Dewan has also drawn the attention of the court to certain other provisions of the Act which have effect outside the state of Chhattisgarh and thereby give the state enactment to extraterritorial operations. Section 12 of the Amendment Act defines off-campus centers, which means a center of the university established by outside the main campus, within or outside the state, operated and maintained as its constituent unit, having the university complement of facilities, faculty, and staff. Section 2G defines offshore campus, and it means a campus of the university established by it outside the country, operated and maintained as constituent unit, having the university and complement of faculties. And Section 37 says that The object of the university shall be established to main campus in the Chhattisgarh and to have study centers defined place of India and countries. In view of the Article 245, one of the Constitution, Parliament alone is the competent to make laws for the whole or any part of the territory of India, and legislature of a state may make laws for the whole or any part of the state. The Imperial Act, which specifically makes provisions enabling the university to have an off-campus center outside the state, is clearly beyond the legislative competence of this university. This is the case, Lordship. The Lordship, that letter, page 89, Lordship, it says that the course of study is off-campus mode, Lordship. If it is off-campus mode, Lordship, then by operation of the law laid down by the Honorable Apex Court, Lordship, it is not permissible, Lordship. Paragraph 60 also. Because, Lordship, for the off-campus or any mode, Lordship, the Parliament state alone is the competent authority to make laws, Lordship. The particular Annamalai University is a state university, Lordship. He has no authority to operate centers, Lordship, beyond the legislative mandate given by that particular university. He cannot operate off-campus, Lordship. And the letter, it's clearly reflected that the course of study is off-campus mode, Lordship. If the study is off-campus mode, Lordship, the degree which is obtained by way of off-campus mode, Lordship, we are not accepting it as per the law laid down by the Honorable Apex Court.
Where is the material to show that you have not accepted it?
It is, Lordship, the page 89 itself. Page 89 itself, Lordship. Page 89 says that the course of study is off-campus mode, Lordship.
No, while exercising, while doing, considering his case.
It is not required, Lordship.
It is required.
It is not required as
Selection process.
Lordship, the document itself says that. If petitioner denied the document, Lordship, or we denied the document, Lordship.
No, no.
It's a document annexed by the petitioner, Lordship.
You are arguing something which is not on record.
No, Lordship. The point is, Lordship, the particular university itself clarified that the course of studies of campus mode.
No, any exercise, that's why we would like to see any exercise, any material.
On that ground, we have rejected, Lordship.
Where it is?
On that ground, we have affidavit, we have stated,
Where it is?
we have stated.
Record.
Lordship,
You are improving your case. You are trying to explain your.
I am not.
You are trying to. The state is trying to explain your action by your affidavit.
Lordship,
on record, on the ground.
way of
what do you
affidavit,
exercise?
by way of affidavit also permissible as per paragraph 63 of the National Highways judgment delivered by the Honorable Apex Court, Lordship, in February 22, Lordship. Paragraph 62, Lordship. We can, Lordship. Paragraph 62.
Without considering.
We considered it, Lordship. We considered it in our affidavit. We have, again, my Lord, may kindly come to our affidavit, Lordship. What is our stand?
We have seen it.
What is our stand, Lordship?
You have taken the stand. On the ground, what is, while considering his case, what was the material you have considered?
Lordship.
If you have not done, you tell us you have not done it. It is not required. If you have done, show us. That is
Lordship,
like to see
on the documents itself says that my submission is, Lordship, the documents annexed.
whatever your submission, you
Lordship.
show us if there is anything, any exercise by the authority. While considering his case,
That's why.
exercise
That's
has
why.
been taken or not.
That's why Honorable Court remand back the matter to the authority to exercise its Lordship.
That's why we are
That's
asking
why.
whether this has been done or not.
That's why it is not done. That's why authority
You
has.
said that
Lordship.
you said you will show it
Lordship,
2 o'clock. You are
I am
not saying
saying,
anything.
Lordship, the Honorable Single Judge view is that you are not act upon the judgment delivered earlier judgment, Lordship.
Yes.
So Honorable Single Judge says that, Lordship, you reconsider it after examining the validity and otherwise, Lordship. Here, Lordship, the document itself says that I am arguing on the basis of the law point, Lordship, not facts, Lordship.
But then you cannot say that we cannot look into the facts.
Mr.
Law
Gogoi,
comes from the facts only.
Mr. Gogoi,
Lordship,
from the documents produced by the appellant,
Lordship,
he did not do any off-campus studies.
it says that, Lordship. It is the document. It cannot be.
His admit card indicates
cannot
that
be.
He went there,
It
sat
cannot
for
be,
his
Lordship.
exam,
It-
and then
it-
he came
it
back.
Cannot be, Lordship. That
How
this
can-
is
how
this is
can-
the clarification.
How,
This is
how,
Lordship, the mere appearing the examination in a particular institute is not enough, Lordship. The clarification given by the university itself, Lordship. The university itself says that the course of studies of campus mode. This is not my document, Lordship. This is not a document authored by the state of Assam, Lordship. It is a document authored by the public information officer of the concerned university, Lordship. Mere appearing an examination in a particular center, Lordship, it cannot override the information given by the particular university. University itself says that, Lordship. This document was not annexed by us also, Lordship. It is on record, Lordship. It is on record, Lordship. It is on record, Lordship.
There's nothing on record to show that marks were not allotted to the appellant because his MPhil certificate degree is not recognized or cannot be accepted. There's nothing on record. Just that we would like to know. Yes or no?
the other two selection board
Ah.
gave full marks.
That part I will come. That part I will come.
That part we would like
Rightly, wrongly, they have given marks, Lordship.
Consisting of the same persons.
Consisting of the same person, there may be same person, Lordship. They may realize later on he is not entitled for that marks. As per the UGC's regulations, as per the law laid down by the FA, if one wrong is committed by same selection body, that cannot be repeated, Lordship. That cannot be repeated. Even Honorable Court give a judgment in a wrong footing, that cannot be repeated in other case also, Lordship. This is the observation of the Honorable Appeals Court. That is judgment to the action. Yes.
We're conscious of that. You don't have to tell us all these things. You come to your facts and come to the law. Let us understand your facts. You are not able to show that even the facts. You are just jumping to the law. Law will come later.
Facts is there, Lordship. The document itself says.
Would like to know some facts and you are not able to show.
Document itself says that, Lordship, this is off-campus mode. There is
Forget about that. Any exercise.
without
I'm
that
repeating. We're repeating it.
without that document, Lordship.
There's nothing.
With apology, Lordship.
There's
Without that,
nothing.
if that document is not there, Lordship, my submission will be other way. It is a record on record, Lordship.
That we have seen.
It is
But
on-
we would like to see the exercise done by the selection committee. Why has not been rejected? Because this appeal degree is, we're repeating. Just wait.
If that is the point, Lordship.
All your horses.
Lordship,
Just wait.
Lordship.
If there is no, if anything is not there, you cannot show it. Be fair and frank. That exercise has not been done. That it was not a ground that his case has been rejected. I mean, no marks were awarded because it is not recognized. That was not the case by the selection committee.
If that be so, Lordship, it's a premature appeal, Lordship.
What?
It's remanded back to the authority to consider it. Authority till today not considered, Lordship.
Thrice.
Lordship.
Remanding it back twice.
Lordship.
So that's why appellant is
Lordship.
before saying even if we go 3 times, what's the point?
Lordship.
We don't know what will happen
That
again.
if Lordship going to the law points and other merits, then I have to place everything, Lordship. I have to place everything. It is up to the Lordships whether Lordship accept my submission or not, Lordship. It is my duty to point out on the basis of the materials, Lordship.
Why you were habit of saying that, always saying that it should up to the the Lordship to accept or not accept. You may accept. You don't have to say that.
Lordship. I apologize for that. Otherwise also, Lordship.
If it is consonance with the law, obviously we'll accept.
Otherwise,
If it is
Lordship.
off the track, if
If-
it's not
If
as per what you understand the law, if it's not, it will not.
if Lordships decided the issue,
Unnecessary arguments should not be made.
decided the issue regarding why not granting the marks, then my submission is that, Lordship. Again, I am repeating, it's a off-campus move.
You're banging on para 6 of your affidavit in opposition.
Para 6 of our, not only para 6, I am on the records of the documents which was annexed by the petition.
You read para 6 properly, you see that notification on which you're banging.
I have already read, Lordship, already perused.
There's nothing there with
Lordship.
regard to
It's
distance.
a off-campus moot, Lordship. This particular notification is for, again, my lord may kindly come to that particular notification.
Page 127.
Lordship, kindly come to this particular notification.
No. 141.
Lordship. The heading is Lordship off campus. Heading is off campus, Lordship. Functioning of off campus center, Lordship. It's a off campus center. Then again, my lord may kindly come to page 89, Lordship. It's a off campus moot, Lordship. It's a off campus moot. It's purely covered by this Lordship, that notification, Lordship. If it is says that only distance moot, Lordship, issue is defined, Lordship. The document itself says that, Lordship, it's a off campus moot, Lordship.
This memorandum is of 2012.
Lordship. This, after the coming of the judgment of Lordship,
got his MPhil in 2008.
Lordship, this memorandum, earlier also I have said that, Lordship, after the judgment delivered by the Honorable Apex Court, Lordship, in Commercial Institute and Professor Yespal, this document is no value, Lordship. We are bound by the Lordship, the law laid down by the Honorable Apex Court. If Honorable Apex Court barred it, Lordship, by way of notification, we cannot, Lordship. We cannot develop our case. We cannot, Lordship, reject the case of the petitioners also. If one law is laid down by the Honorable Apex Court, Lordship, by way of notification, Government of Assam, even, Lordship, by Union of India also cannot, Lordship, negate it. Law is well settled, Lordship. So, Commercial Institute of Degree and Technology also, that day I am, Lordship, referred.
Which one?
Commercial Institute of Degree and Diploma, Lordship. That day I have handed over one copy, Lordship. The Placitum C also says that the statutory authority cannot operate beyond its territorial limit. Here I am relying paragraph 18, 19, and 20, Lordship. 18, 19, and 20, Lordship. Even that in the state of Uttarakhand, the territorial limit is within the 4 concerned district, Lordship. The particular institute offered off-campus mode beyond the 4 district. So, Honorable Supreme Court says that we cannot act beyond the boundaries, Lordship. Paragraph 23, Lordship. The study center of the appellant being situated in a Nainital is also beyond the territorial jurisdiction. Off-campus mode is, Lordship, always a beyond the territorial jurisdiction, Lordship.
Yes.
Lordship. It is an admitted fact that it's a off-campus mode, Lordship. Regarding MPhil, my submission is this, Lordship. And Lordship, regarding Lordship, the experience part, Lordship. Deputy.
Yes.
Lordship, permit, I can go to the second point, Lordship. Regarding Lordship, teaching experience, Lordship. So my lord may kindly come to the Asarani Bomma's case, Lordship. That detective.
Which one?
Asarani Bomma, Lordship. Paragraph 18, Lordship.
Yes.
So submitted that OM rated so Lordship. Just I am quoted point 3, Lordship. The teaching experience shall carry 2 marks for 1 year of experience of teaching undergraduate in a state group recognized colleges. Subject to maximum of 10 marks, this will be related to actual total hours of teaching imparted by a candidate in a particular year with the standard of teaching hours of a regular assistant professor as per UGC guideline. My lord, may kindly mark it. As a regular assistant professor as per UGC guidelines. Then my lord, kindly come to page 127 of the Lordship, appeal memo, Lordship.
Yes.
The petitioner has projected that he is serving as assistant professor in the Karimganj College since 01/07/2005 and presently he is the head of the Department of Computer Science Application under self-financing scheme of the said college. My lord, may kindly mark it.
Well, we are reading from page?
Page 172, Lordship.
Oh, 172.
I'm sorry, Lordship. 172, Lordship. 172. The petitioner has projected that he is serving as assistant professor in the Karimganj College since 01/07/2005 and presently he is head of the Department of Computer Science and Application under self-financing scheme of the said college. He is not a regular assistant professor there, Lords. Now he is applying for the post of assistant professor, Lords. He was a Lordship assistant professor in a particular college, Lordship. It's a self-financing Lordship department. Now, Lordship, another point, Lordship. For the purpose to be appointed as a assistant professor, Lordship, he should be fulfill the UGC's required qualification, Lordship. Whether at that time of appointment, Lordship, he has the UGC's required qualification or not, Lordship. If he has the required qualification, Lordship, the teaching experience which is acquired by the petitioner at that relevant point of time, that marks should be given to the petitioner, Lordship. If he is not the Lordship required qualification, Lordship, that period cannot be counted for as a teaching experience, Lordship, as because he is not a candidate with due qualification of the UGC, Lordship, prescribed by the qualification of the UGC. So for that purpose, Lordship, 2008 regulation already I have supplied, Lordship, 2008 UGC regulation, Lordship.
When did you supply?
In first half, Lordship, when Mr. Somoy is submitting, Lordship.
This one,
Lordship, this one. Yeah, I'll this one, Lordship also.
you don't have extra copy.
My lord may directly come to page 4, Lordship.
Hmm.
Internal page 4, Lordship. 4.4.0. It's a lecture, Lordship. 4.4.1. Humanities, social science, science, commerce, education, physical education, foreign language and laws. Good academic record with at least 55% of marks or equivalent grade of B in the 7-point scale with letter grades O, A, B, C, D, E, F, master's degree level in the relevant subject from the Indian universities or an equivalent degree from a foreign university. Besides fulfilling the above qualification, candidates should have cleared the eligibility test for lecturers conducted by the UGC, CSIR, or similar tests accredited by the UGC. So, Lordship, for appointment as a Pusta assistant professor, Lordship, he should possess the 55% marks in the master degree, along with NET, SLAT, or PhD, Lordship. Although it's reflected only for NET, Lordship, stated conducted SLAT. SLAT was also recognized by the UGC, so he should possess the NET, either SLAT, or PhD, Lordship. There is no scope for MPhil, Lordship. Nowhere. Even after that, Lordship, that was also adopted by the state of Assam, Lordship.
So just I'm taking leave for 1 minute.
Chamma, have you got the instructions?
But I just called to them. They said that for verification of these documents, they need some time because somebody has to go there and verify. But number two, so far as giving examination in university is concerned, prior to that, we have to see if it is an admission in off-campus center, then even if he goes there for examination, then also it is.
That will still be an off-campus.
No. There is no role of any off-campus.
So the issue is whether he takes admission in that particular university.
Yes.
If he has taken,
But it reflects my friend said, I've not seen, but my friend says that is admitted, you was admitted for an office. So if that is so, then perhaps.
Difference is there is a two type of distance. One is distance mode and other is off campus.
Off campus is ruled out because in the
off campus it's not permissible. It's not permissible at all.
Yes, off campus
But
can be
distance
Distance is when one has to apply directly to the university, following an advertisement or following a prospectus.
no, that's why distance mode is permissible.
Permissible.
It's permissible, but he has to apply directly there. If there is any admission test and all, then you have to go there for admission test. Then he takes admission. Then the
for
course material will be sent to him through post, and he will study by himself and go there for an appearance.
For examination, he has to go.
He has to go. But if
Then
he
that
takes the
can-
admission through a franchising arrangement, that
So
means
off campus is
not at all
permissible,
not at all.
but the distance mode is permissible.
Distance mode is permissible, Lordship, subject to the condition that it's the main campus.
That is what.
That is what we were saying.
No, Lordship. The document itself, the university clarified. It is the RTI application filed by the petitioner. The document says that, Lordship. Again, I am reciting, Lordship.
That we have
Off
seen,
campus.
that-
The course of study of campus mode. It's enough, Lordship. Nothing is required. For many clarification of the UGC also not required, Lordship. The university itself clarified, Lordship. No clarification is required from the UGC at all, Lordship.
Yes, proceed.
So, Lordship, the 1998 UGC regulation, Lordship, it says that the particular person should possess the 55% marks or equivalent grade given by the foreign university along with NET lordship. The state concerned state has adopted SLAT also, so NET, SLAT and PhD lordship. This is the required qualification for post of lecturer. That was also adopted by the government of Assam lordship. It's a notification of 2000 lordship. Just I have supplied one copy. I'm extremely sorry lordship, because during the course of argument that point was erased. So lordship may lecturer lordship. Lecturer good academic record with at least 55% of marks or a equivalent degree at the master's degree level or any equivalent degree from any foreign university besides clearing of national eligibility test lordship. This is the required qualification. There is no scope of MPhil lordship. This is the required qualification. And time and again lordship, after that UGC has 2009 regulation also come. In between 2006 regulation also come lordship. Everywhere the eligibility condition is lordship, NET or SLAT or PhD lordship. Nowhere MPhil. MPhil is no point of time. MPhil is a required qualifications for the post of lordship, lecturer lordship. Now lordship.
No, then the issue comes.
Lordship.
Page 86.
Lordship. Lordship.
Yes, research performance. Roman 2.
Lordship, this is for awarding marks in respect of a heading lordship research performance.
Yeah, that's what.
Lordship. Now that part in respect of MPhil and PhD degree lordship, not for teaching experience lordship. For the teaching experience lordship, he should be qualified as a teacher to be recognized by a degree with valid degree lordship. With a degree which is required for lordship.
No. Teaching experience will come later.
Lordship. Now, I have already submitted regarding MPhil part lordship.
MPhil part.
MPhil part.
Now that he has his MPhil.
Lordship.
Whether it is off course, off campus.
No
or
dispute,
to
lordship.
distance would.
No dispute.
That will consider.
No dispute, lordship.
But then since he's having an MPhil degree,
lordship,
he's eligible to get 5 marks. Correct.
Lordship, 5 marks.
The reason is
subject to condition that lordship.
Subject to the condition that it is a valid degree.
It is a degree which is acceptable by the UGCs as part of law laid down by the Honorable Apex Court.
And the question is, UGC, it is recognized by the UGC and Government of Assam approved university.
Regarding recognition part lordship, there is no dispute. Even lordship, we admit that lordship, that degree was that university was recognized by us lordship. Then also lordship, whether the off-campus mode degree lordship, we can take into account or not.
That part we decide. Whether it is an off-campus
lordship
degree
the lordship,
or it is a distance mode degree.
Lordship,
that's all.
That part my lord have to decide in respect of MPhil lordship. MPhil degree. And the document which was annexed in the appeal memo, it clearly shows that it clearly reflects that lordship, that particular mode of conferred the degrees of campus mode. It's a clarification issued by the particular university in the RTI reply lordship. Now in respect of second point lordship, regarding teaching experience part, I have already said that lordship, he should be possess all the requisite qualification prescribed by the UGC to be a lecturer. Then his teaching experience part can be or should be counted by the authority for awarding the marks lordship.
Since 2014, he is having the PhD.
Lordship,
doctorate.
No issue lordship. In 2017, he has awarded the PhD degree and that part there is no dispute lordship. He is entitled for that part lordship. If he is completed the 1 year period from the conferment of the degree lordship.
That's where 2 marks.
Lordship. If
15 and 16.
the 1 year period lordship, he is lordship after obtaining the PhD degree, he will definitely get the 2 marks lordship.
2 marks for one
We cannot deny and deprive lordship.
That's fine. That's fine.
Lordship. But the argument advanced by learned senior sir is that the period which he has rendered service before obtaining the PhD degree should be treated as an experience part lordship. Now the moot question is this. whether that part can be counted as a valid fishing expense or not. That point Lordship has to decide. For that purpose, Lordship,
Become eligible. Having that already present. But before that, because those after having a doctorate and net is already. So he often then, sorry, doctorate degree, 14, 15, 16, 18, 17. 2 months is maybe. Okay.
You have any more to want?
Lordship, I have just opened my argument, Lordship. In the second point, Lordship. I just opened, Lordship.
Where privacy acceptable your second argument, no further.
That part, Lordship, I can only place one judgment of honorable apex court, Lordship. Regarding this, Lordship, some document.
Mr. Gogoi, if you are just opening your arguments, then we'll keep it part-heard.
Lordship, part it and hear it, Lordship.
In the meantime, Chamma, you can.
Second part and also, Lordship, one third point also there, Lordship. It will take 1 hour, Lordship. I will take, Lordship.
There are lots of cases.
I will take 1 hour.
It'll take more than 1 hour.
So he has raised only, Learned Seated Council has raised only 1 point.
That
Fundamentally.
we have to justify that point, Lordship, by way of our.
Why you are having 3-4 points?
3-4 points is because Lordship has to determine whether he is entitled to marks or not, Lordship.
We are still not satisfied with the explanation given by you why you are not accepting his MPhil.
MPhil.
So you come to
That satisfaction part, Lordship have to heard my second limbo argument, second part argument. Then Lordship, everything will be clear. The picture will be clear, Lordship.
Just see whether he took admission in.
But Lordship makes just a direction to the UGC for filing an affidavit clarifying this issue. This will help him bringing everything on the top.
Then to keep it part-heard will be
Yes,
dangerous.
Lordship will keep it part-heard.
1 month you can, Lordship may.
Lordship will reflect it. Assisted by unique concept of the appellants. Also heard Mr. K. Council Higher Education. For the respondents 1 and 2. Stop. The respondent number 12. Oblique the UGC is directed to file an affidavit indicating as to whether the applicant took admission in the Annamalai units at
Annamalai University, Chennai.
At Chennai. That much only you will require?
My lord, indicate that if we require, my lord, we can verify and come back and say that whether this is a valid.
Also, as to whether the MPhil obtained by the applicant is a valid degree in terms of the UGC guidelines. When do you want?
It needs some time.
It's a very old matter. Your Lordship may give a time frame.
Yes, his Lordship will fix it, but give me some reasonable time.
Please for the hearing. This month?
This is
Better
yes,
month,
yes,
this month.
end of this month.
And
Before
means there is a vacation.
yeah, before vacation.
You'll be around. After that.
Second.
22nd, my brother will not be there.
Oh.
It may
The
be.
very first week of January.
No, 19th, my lord, 19th of December.
If this bench is available.
Your Lordship will not be here.
19th.
Yes.
Justice Ete will not.
My lord, then when his Lordship is available, your Lordship will fix.
First week.
My lord may indicate as per roster lordship, then it will be.
No, roster.
Then we will not keep it part.
Lordship will have to be here.
Substantially, lordship is hard.
Substantially, more than substantially.
Practically it's concluded.
Yes.
Yes, exactly. That is what.
My lord may indicate as and when lordship is available here.
Okay. Fourth January.
Much obliged.
Item 5.
They have a copy of this order.
You can apply, it will come on online.
Oh, yeah. If I get it by tomorrow, then.
Lordship, in this case, matter, please maybe adjourn your letter. My senior Mr. SP Roy, due to some personal inconvenience, cannot argue today, Lordship. Actually,
Yes.
the program which has been fixed in the bar. And
Cycle.
Lordship, since senior is having some difficulty.
Got Mr. PJ Cycle and the city council for the applicants. On request made on behalf of Mr.
SP Roy.
SP Roy. Learned, council appearing for the
Respondent. Date may please, 8th, your Lordship.
this month, this week.
Yes, your Lordship.
6th, otherwise, no.
Eight.
Item 6.
May I please, Your Lordship? It was fixed for the instruction by the last order schedule was finalized.
Any answer?
I have not received it. I pray for a short time, Lordship.
But this was when for the appellant. Mr.
V. Chaudhary for PWD.
B. Jagri, standing council, PWD. Is allowed how much time?
2 weeks, Lordship.
2 weeks time, 2 weeks. When it was started. Please start.
Item 9.
May it please your lordships. These are two writ appeals, item 9 and 10, arising out of the same impugned judgment. In fact, for your lordship's convenience, in fact, since the file is very voluminous, we had just prepared a short list of these pages that may be relevant, may be convenient for the court lordships.
Who is on the other side? You are appearing? Who is the standing council health department?
Now, these two basically lordships, in these two appeals, there are a total of 34 appellants. 17 from Goalpara and 17 from Dibrugarh district. They were all appointed as grade 4 employees in 2025 against vacant and substantive vacancies under Joint Director Health Services and continued as such until their services were terminated in 2019. All through their service period, they received the regular salary without break. The termination of their services after rendering 14 years of service has been upheld by the learned single judge by the impugned judgment. This is the sum and substance, lordships, of the appeal that is pending before lordships. Now, before I proceed, our termination by the state is on the ground that our appointments are fake. Whereas ultimately the learned single judge did not uphold the termination on the ground it is fake, but on a separate ground which was never raised previously. That is, it is divorced the rules and it doesn't have approval. Now, lordship, if we confine to the state's case that our appointments are fake, when we are talking about something being fake, that means from the very concepts, it's conceived in fraud. Now, please see a certain relevant documents and certain relevant facts. Please first see the advertisement itself, which is at page 163. Straight. Lordship will bear in mind, this is an advertisement published in the newspaper. Please kindly come to page 163. May I place the advertisement, page 163? My logistics. Volume 1.
163?
Yes, Lordships. In fact, when I was saying this, Lordships may implement one thing, some best practices. Out there, we mark it as volumes. So we can immediately say volume 2, volume 3. It's convenient for the court to also immediately go into that volume.
So there's no such thing as volume 1, 2, 3.
Therefore, I believe that practice is not here.
Okay. Yes, 163.
Page 163. Applications are invited in standard form as published in the Assam Gazette Part 10 for 70 posts of grade 4 under the establishment of Joint Director Health Services Gwalpara in the scale of pay so and so, plus other allowances as admissible under the rules. There shall be usual reservation for scheduled caste, scheduled tribes, scheduled tribe hills, OBC, MOBC candidates as per government rules. Educational qualification application must have read up to class 8. Age candidate should not be less than 18 years and not more than 36 years. As on 1/1/2005, the upper age limit is relaxable by 5 years for SC, ST Plains Hills candidates only. The candidate should apply along with attested copies of certificates and 1 passport size photograph. Application should reach the office of the undersigned on or before 17/1/2005. Now, what Lordship will have to please note that this advertisement is published in a newspaper. That is the next page. Please have a look at the advertisement that is published in a newspaper. Now, this appointments are set, the appointments that started with these advertisements, public advertisements in terms of Article 16 are now sought to be said to be fake. Now, please see the next document that I wish to show. And this advertisement was on 3/1/2005. Please see page 1172. A proper select list was drawn up.
1172.
1172.
That is in which volume?
That would be Lordship's volume. Volume, I believe, Lordship, it should be the 4th, though we have not marked it. Oh. 1172.
This is difficult to.
I know that, therefore I was telling my friend, but he says this practice is not here.
How many volumes are here?
5. In the first case, there would be 5 volumes, Lordships. Serial pagination is continuation. I'm 6.
There's 6 volumes.
6 volumes.
Yes.
Page 1172. I'm sorry for the inconvenience.
There's no 1172.
1172.
Volume 5.
Volume 5.
Now, list of selected candidates for the post of so-and-so. This select list is valid for the calendar year 2005. Now, this is the typed copy. And if Lordships will see page 1177 is the unsigned, is the actual copy which was typed, and this is endorsed by the official seal. So there is a proper select list drawn up. Post the appointment, post the advertisement and selection. And then Lordship will kindly see to our appointment order. Again, please come back to volume 1 at page 167. Volume 1, page 167. Similar appointment orders are issued in respect of all. I'm just placing one for your Lordship's consideration.
Yes.
May I place page 167?
Yes.
There is a dated so-and-so, subject to discharge without notice and without assigning any reason thereof, Sri Narayan Prasad Rabha, son of so-and-so, village so-and-so is hereby appointed temporarily as grade 4 and posted at Rongjuli PHC Goalpara, sanctioned by creation letter number so-and-so in the pay scale so-and-so and other allowances as admissible as per rules. The appointee should join his duty to the above mentioned place within 15 days from the date of issue of this order. Failing with the above mentioned, appointment shall stand automatically cancelled. Now, this 15-day notice that has been given is as per Rule 10 of the 1997 rules, which the High Court has now said these appointments are divorced those rules. So, Lordship may kindly make a mark that stipulation is in the rules. And secondly, if Lordship will see down the page, this appointment letter is marked to all the authorities, to the Accountant General, to the Director Health Services, Assam, to the Treasury Officer, Accounts Branch, and the person concerned. So this copy of the appointment letter is served to every officer required in the year 2005 itself. So to now contend in 2017 that this whole process was fake is a little difficult to comprehend, Lordships. Now, Lordships, what happened basically, there was certain fake appointments in the health department. Those were with respect to surveillance workers. That there were certain number of surveillance workers that were appointed possibly fake. We are not surveillance workers. So in 2017, for the first time, the government tells the department that we believe that there is some anomaly in the appointment. So please verify the appointments of these surveillance workers. That letter, your Lordship will find at page 1124. $1,124. Hi. Oh, sorry.
Page 327.
I'm sorry, Lordship, that is page 327. I'm extremely sorry. I'm sorry, Lordship, that is page 327. Same word. Sorry for the inconvenience, Lordships.
Yeah.
This communication is dated 27th of March 2017. It is from the Secretary, subject regarding release of salaries of surveillance workers. With reference to letters on the subject cited above, Lordship Justice Ete is there. Page 327, Lordships.
Yes.
With reference to the letters on the subject cited above, I am directed to request you to release the salaries of 953 numbers of surveillance workers whose credentials were found to be genuine by letter number so and so, dated 7/3/2017 and consolidated statement of verification. I am also directed to request you to give one last opportunity to those surveillance workers who did not appear before the screening committee to appear before the same once more, failing which suitable steps may be initiated for their termination. Notice in this connection may be given in the form of newspaper advertisement, also at an early date. Now the next paragraph is important. Further, you are requested to complete the screening process of the remaining surveillance workers and start similar process for other posts also under our establishment so that their genuineness can be verified. A report in this connection may be submitted early. So this is where we come in. Surveillance, initially the whole exercise was for surveillance workers. So with these directions, a screening committee is constituted. And we are called to submit our documents. We go, we submit our documents, it's verified, and we come back. Then initially a show cause notice was issued to us, stating certain reasons. Some of persons, there were 11 writ petitions, by the way, before the learned singles. So some people from certain part came to the High Court challenging that. Now please see the first order that the High Court passed, which is at page 457.
Yes.
This case was taken up on 16/5/2018 and was adjourned to enable the departmental lawyer to receive urgent instructions with the following notings. As the petitioners were appointed as grade 4 employee by the Joint Director of Health Services, Goalpara, the implement of the appointing officer's response number 6 is allowed. The necessary correction of the cause title should be made by the learned counsel, Mr. R. Sinha. The process of recruitment of grade 4 staff in Goalpara district was started with the advertisement dated 3/1/2005 that I have already shown, lordships, issued by the Joint Director of Health Service Goalpara, and 79 petitioners claimed that they were appointed in pursuance to the said recruitment notice. The authorities in the health department noticed large number of grade 4 employees were serving illegally in the department, and the bona fide of their appointment was suspected. To identify the non-genuine employees, a screening committee was constituted on 17/5/2017. And thereafter notices were issued to the concerned grade 4 employees and the appointing authority to present themselves with all documents relating to their appointments. The learned senior counsel, Mr. U.K. Nair, submits that such screening was undertaken in June 2017, August 2017, and March 2018, but the authorities have failed to reach definite conclusion in the matter. Now, another notice is published on 27/4/2018, which identifies the names of around 80 non-genuine grade 4 employees from the Goalpara district. And on that basis, the concerned employees are directed to report before the Director of Health Services between 30/4/2018 to 25/2018. The petitioner's counsel submits that the department may be within its right to identify the non-genuine appointees, but the concerned category must be intimated on what basis they are categorized as non-genuine employees. The counsel refers to the notice issued so far to show cause that no specific ground is mentioned in those notices, including the last one published on 27/4/2018. To receive urgent instruction on the above projection, Mr. B. Gogoi, the learned standing counsel for Health Department, prays for time, lists the matter accordingly on 18/5/2018. The basic apprehension projected by grade 4 employees in the Health Department is that they, being suspected to be non-genuine employees and were subjected to repeated screening, now they are expected to appear once again before the authorities, as per the latest notice published on 27/4/2018. The petitioners contend that in none of the notices issued by the Director General of Health Services, the precise deficiency in the matter in the petitioner's appointment status was indicated, and the employees are entirely in the dark as to why they are being suspected and subjected to repeated screenings. On the other hand, Mr. D. Saikia, the learned Additional Advocate General, submits that the last notice, which was issued on 27/4/2018, was intended to enable those employees who did not appear before the screening committee earlier and failed to produce the documents relating to their appointments. It is also another opportunity to everyone to furnish additional grounds if needed. The respondent's lawyer submits that eventually, when the screening process gets completed, individual decision for each employee will be taken with due intimation to the affected employees, and only thereafter, if anyone is found to be non-genuine, the appropriate order will be issued. With the above projection, the learned Additional Advocate General urged upon the petitioners to appear before the Director of Health Service during the ongoing screening exercise. The above stand taken by the state authorities should considerably assuage the apprehension of the petitioners. The petitioners are therefore directed to avail the opportunity to prove the bona fides of their appointment so that the authorities can reach an appropriate conclusion on their service status. As the proposed screening is scheduled to end on 25/2018, Mr. D. Saikia, the learned Additional Advocate General, assures that it will be extended until 22/5/2018 to enable everyone to participate in the screening process. Next line is most important. If anyone is found to be non-genuine amongst the serving persons, the authorities must, however, indicate the precise deficiency and afford opportunity to the affected employee before any adverse action is taken. It is ordered accordingly. Despite this, they issue another show cause notice, repeating the same mistake. We again had to come back to the court. Now, please see the next order, the second order, which is at page 623. (31/7/2019), Lordships. Page 623.
Yes. Yes.
Yes, Lordships. The order dated 31/7/2019. This order will dispose of the series of writ petitions. Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by so-and-so, learned counsel, so-and-so and so. In this batch of writ petitions, petitioners have challenged the legality and correctness of the communication dated 6/6/2019 of the Director of Health Services Assam addressed to the Joint Director of Health Services, informing the latter about a list containing names of grade 4 staff whose appointments have been found to be fake by the scrutiny committee, and directing the joint directors to issue individual show cause notice as well as the consequential show cause notices issued to the individual petitioners. The court has passed an interim order in all these cases to the effect that an impugned show cause notice issued to the petitioners should not be acted upon. Petitioners are serving as grade 4 employees in different establishments of Joint Director of Health Services in the state of Assam. Their appointments were suspected to be non-genuine, and accordingly they were not paid salary. This led to filing of a large number of writ petitions in this court. In writ petition so-and-so and other connected cases, this court passed an order dated 18/5/2018 to the effect that since the state government had decided to constitute screening committee to find out non-genuine employees, petitioners should avail such opportunity to prove their bona fides. It was directed if anyone was found to be non-genuine, the authority should indicate the precise deficiency and afford opportunity to the affected employee before taking adverse action. With such directions, the said batch of writ petitions were disposed of. Notwithstanding such direction of this court, communication and subsequent show cause notices were issued. Director of Health Services has filed an affidavit. In the said affidavit, it is stated that a decision has been taken by the health department to withdraw the impugned show cause notice and to issue fresh show cause notice mentioning the specific deficiencies found against each illegal fake employee, including the petitioners, so that each show cause employee gets an opportunity to know his or her deficiency and to respond effectively. I'm emphasizing on the word respond effectively. In this regard, direction has been issued on 5/7/2019 to the Joint Director of Health Services of the concerned districts who had issued the impugned order show cause notice to withdraw those show cause notice and to issue fresh ones indicating specific deficiency. In view of the stand taken by the respondents, immediate grievance of the petitioners seemed to be redressed. And accordingly, the petition was disposed of. Now, Lordships, what I wish to show you, Lordships, is the final show cause notice that has now culminated in this termination. Please, Lordships will kindly come to page 647. This is the final show cause notice which has culminated in our termination. Page 647. Lordship, you have seen the orders passed by the High Court and what not did.
Yes.
This is dated 31/8/2018. The dates could differ from petitioner to petitioner, but generally this is the form. This is what was sent. Show cause notice to fake grade 4 employees, letter dated so-and-so, with reference to letter number so-and-so quoted above of the Director Health Services, the following deficiency have been found against you as suggested by the screening committee during screening. Appointed by Joint Director Health Services, Goalpara, letter number so-and-so, no DHS approval, no SIU approval. Hence, you are hereby show cause as to why your appointment should not be treated as fake, having the above deficiencies, and then we were given 7 days time. Now, Lordship will, just pausing here for a moment, Lordship will see that the state is relying on a report of the screening committee to issue this show cause notice. So that is the foundation. That is the foundation of this show cause notice. Now, kindly see my response to it. I file a detailed response to it. Which response Lordship will see at page 690. Now, please come straight to para 2 that is relevant. That, sir, as per direction of the Honorable High Court, while order dated 18/5/2018, that Lordship had seen, passed in WPC so-and-so, and other analogous matter, writ petition challenging the same, along with other similar citizen persons, wherein the Honorable Court directed that if anyone is found to be non-genuine among the serving persons, the authorities must, however, indicate the precise deficiency and afford opportunity to the affected employee before any adverse action is taken. And pursuant to the aforesaid direction of the Honorable Court, I had appeared before the screening committee, and as such, the screening committee should have stated the deficiency, and hence, in view of the same, I earnestly request you to furnish me the minutes of the screening committee and the decision so arrive with respect to my appointment, because the non-furnishing of the minutes of the screening committee will be highly unjustified and cause serious prejudice to me. Further, I most earnestly request you to give me 10 more days time to enable me to submit a reply after furnishing of the minutes of the screening committee. Now here and then, that, sir, in the second round of litigation filed by me challenging the impugned show cause notice dated 10/6/2019 by way of...
Can we skip that?
Yeah, no, yes. So basically, the issue that we were raised that, please give me this. This is something adverse to me. Please, so that I can at least have a look and do effective. Now, this aspect was specifically pleaded in the writ petition, in the proceedings before the High Court. But that, Lordships, if Lordship would like to see, is at page 1404. That a specific ground we had raised that this is something which is against us, please supply us. Page 1404.
Council, some pages are being torn off. See,
I'm so sorry for the inconvenience, but spiral is an idiot.
Why can't you do some spiral binding also?
Yeah, actually, I'm just inquiring that why did you not spiral bind it? Oh, dear.
Your Lordship, actually, while reporting it, they say that once it is reported, you cannot do it. Only with the permission of the court, you can do it. So after the matter is taken up today, for Lordship passes an order, I'll get it done, Lordship, in a volume-wise manner.
1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404. 1404.
just before para 10, the last few lines. Just before para 10, lordships. The last few lines. In the instant case, the respondents have stated that the impugned action against the petitioner has been resorted to based upon findings of the screening committee. However, the said findings have neither been furnished to the petitioner nor produced before the honorable court, and hence the impugned removal order is liable to be set aside and quashed. Now kindly see how this issue is dealt with by the learned single judge.
Where's the judgment?
Yes.
1460.
It starts at 1460. Kindly see this aspect, how the learned single judge has dealt with it. Please come, lordship, straight to page 1506. 1506, middle of the page. Five, 6, 7, 8, 9, 10, 11. 11th line from the top, lordships. 1506. 11th line. It starts from the only plea. 11th line from the top, lordships. The only plea which has been taken in the replies to the show cause notice was that the petitioners were duly appointed against vacant sanctioned posts and they were regularly receiving salaries without any objection. And the transfer orders of the petitioners also showed that the Director of Health Services knew very well that the petitioners were appointed. It was also the argument of the learned counsel of the petitioners by drawing the attention of the court to office memorandum dated so-and-so that the petitioners being disbursed the salaries by the respondent authorities meant that the petition appointments were made either with the approval of SLEC or with the approval of FIU department in as much as without the approval of the number of salaries, the petitioners could not have been released. Now, the learned single just completely misses out the point of my demand of the screening committee. This is what he has, this is how he has considered the show cause reply that we had sent, lordships. There was a specific plea by us, which has been completely overlooked by the learned single judge.
Although the learned single judge has admitted that there is some element of selection.
Because lordship will appreciate that there is a selection. And today, when you are relying on something which is adverse to me, not showing it to me, we take a specific plea. Despite that, the learned single judge doesn't even note it. So my first submission before your lordship is that this issue goes to the root of the matter. Because if lordship will see, the previous High Court order said we needed effective, we have to be given an effective opportunity. This being the position, lordships, because if lordship will see para 73 of the judgment,
1493.
page 1493, page 1493, para 73 of the judgment, he says, now coming to the case of WPC 1931 and 8820, that is the two writ petitions, the appeals which are before your lordships. The pleading as well as the documents enclosed to show that some selection procedure was initiated. So the court accepts that there is a selection. It is not a fake appointment per se, that there was no selection process, no appointment letter, no select list, nothing. Because since this is because he was handling 11 matters, so of course there could be some cases within those 11 matters where this could have been that there was no selection, there was no appointment letter, there was not. But with respect to the appeals or the petitioners I am standing, even the learned single judge says that there is a selection procedure. And I must also, as an officer of the court, say, lordship, one thing, that yes, to a certain extent, there could have been a slight non-compliance of certain rules. But these appointments can certainly not be termed as illegal. But at the most irregular. And that also I'll demonstrate from the rules that there has been a substantial compliance with the rules. So therefore, my first submission for your lordship's consideration is, if that the screening committee report, which formed the foundational material to declare our appointments as fake, was not furnished to the appellants, despite specific requests and particularly in light of the High Court orders dated 18/5/2018 and 31/7/2019. This has caused serious prejudice to the appellant defense and has vitiated the order of termination. This vital issue has been completely overlooked by the learned single judge. The second, in continuation of this, my second submission would be a perusal of the impugned termination order would indicate that the detailed reply to the show cause notice submitted by the appellants was not considered by the respondents before passing the order. Hence, this is a clear case of non-consideration of relevant materials and non-application of mind by the respondent authority. This is my first submission for your lordship consideration. Though this is a very well-known principle in service jurisprudence, but I'll just show one or two how such issues have been dealt with by the apex court. In certain, I'm not going to overburden lordship, but just one or two decisions if lordship so pleases.
Yes,
This matter has come up for admission today, my lord. It's the first day. Lordship will admit it, lordship will post it for hearing, my lord, on a fixed date, my lord.
I have no problem, lordship.
Yes, instead of my lord going to the
we
apex.
can't have a hearing like this.
No, please, lordship, but there is one thing, lordship. I need a stay of the.
All these pages have been.
I take it upon myself to get the thing. Lordship will just permit us in the order. We'll spiral bind everything and mark it with volumes. So this, I was feeling.
Copy may be served to me also for that.
We will do that. I was myself feeling very embarrassed, lordship, because this is not how a proceeding should really be. I'm very sorry for it, but then something went wrong. I was telling him that why did you not spiral bind lordship? Then he told me that this is not permitted here.
No. In the second case, they have submitted my lord spiral binding.
Okay. Oh, so you have got it.
No, yes, sir.
You have got it, but the
Yes,
court
sir.
is not. I'm so
In the
sorry.
second case, because to check who was again.
But lordship is just that we need a stay of the interim direction number 2, which please see the final directions of the court.
Where is that? Where is that?
Final direction is page 1507. I'm more concerned about 1508.
Yeah.
1508 direction page, that's Roman 2, lordships. In view of the above analysis, this court is of the view has not interfered with the impugned orders of removal. Consequently, in view of the removal of the petitioners from the vacant sanction post, the government may take appropriate steps for fresh recruitment. I need to be protected, lordships, only to that.
Are you taking any steps?
My lord, they have been terminated in 2019. We are in 2023. Even if my lord, this particular order is not there, it's up to the authority to take a call.
No.
For appointment, it's up to the my lord, appointing authority.
But then our interest has to.
It's not that my lord, they were protected by the learned single judge, my lord.
Whatever it is, don't take steps for recruitment.
No, so far as this particular my lord post are concerned, whether they are still vacant or not,
They
I
are,
can't say.
they
I
are.
can't say as on date, my lord. I don't have the instruction.
So I'll issue notice on the interim.
Yes, my lord.
Lordship will kindly see. Lordship will kindly see.
Within 2 weeks.
No, what I'm saying is that I am not saying a blanket stay. Let them go ahead with it, but just save us 34 people. Just 34. I'm not even saying that don't go ahead with the recruitment. Please, for all sake.
No, if they are
But this-
vacant or not.
At least for 2 weeks, please save me. Please, I have to at least if the posts are filled, we have made a prima facie case for lordship's indulgence. So at least 34 posts maybe. There are only 17. That's all I'm seeking. It's rest. They may go ahead, lordships.
No, so far as my lord, this particular prayer made by the petition appellants are concerned, my lord. My lord, this order has been passed hardly, my lord, 1 month back. It's not that within 1 month there will be a recruitment. Let me have the instruction in
No,
that.
but why is the state running shy of making a statement that we'll take leave of this court before we make an appointment?
Definitely. Why not?
Where is your main writ? The first appeal.
First appeal is lordship this 428.
What, Mr.
Manish Goswami.
Manish Goswami, then the counsel for the appellants. Admit. You are appealing on behalf of all?
Yes. Yes, ma'am.
Including the screening committee?
Lordship.
Okay, Mr. B. Goel and the Standing Council Health Department. And just appearance on behalf of all the respondents.
This screening committee was of 2004. So
No, this 2017. Screening committee is
oh, yeah,
2017.
17. What there is on the.
This is the method. Go ahead. July, January,
Whenever convenient to your
the
lordship.
month of January.
After January, February or October.
In the next. The respondents are directed not to fill up the 34 posts held by the applicants
No, if it is still vacant, that may be my lord record.
without the leave of this court.
If they are still vacant.
I'm just saying not to fill up the posts held by the 34 applicants.
No, they have been terminated in 2019. If in the meantime it has been filled up, how can we keep it vacant now?
Not the 34 posts held by the applicants, comma, if still vacant.
Yeah, I will come here.
Till the next. court. The petitioners are also directed to spiral bind the documents in separate volumes before the next deadline.
In February, man.
Okay, February.
The stay applications may be disposed of lordships. Lordship so desires.
Where?
There are two stay applications, 3394 and
In the IA, in view of the order passed. I just don't disposed. This first item is 34K. 34.
17. 17.
Both has 17. 17 in the first.
You make it 17.
Total is 34 between the two appeals.
No, separate appeals, separate orders, make it 17 each.
I'm so very grateful. So very.
Item 11.
You can put up the AC. Yes.
Plus, Lordship, the matter pertains to Lordship selection and appointment to the post of principal in Malowali High Secondary School in Zorat district. I had challenged the selection and appointment of respondent number 6 on the ground, Lordship, that the comparative merit assessment was not done, and Lordship, the composition of the school selection committee was also wrong, because there were 2-3 litigations with the appellant and the respondent number 5. And the respondent number 5 become the member secretary, and necessarily she will be biased against me. And then Lordship, the respondent number 6 had obtained her B.Ed degree from Diomona B.Ed College, that is in another district in Doron district, which is 271 kilometers. And she has obtained her degree in regular mode. The class timing is 10 to 3 p.m. Then Lordship, my another ground of challenge was that Lordship, I had made a specific challenge to her B.Ed degree in WBC 1733 of 2023. That writ petition is still pending. And what happened, Lordship, this writ petition was heard in 2019 itself. 19/6/2019, it was made CAV. Then Lordship, the order was not passed, and the record was also produced by the departmental council. And when the matter was again listed in 2023, it was submitted by the council lordship that the record has been lost in the court. Thereafter, lordship, this honorable court has directed to reconstruct the record. But the department did not reconstruct the record, and the inspector of school taking by favoring the respondent number 6 has simply given a note. And on the basis of that note, lordship, the knowledge single judge has decided the issue. Lordship, I will just like to, for your lordship, 2 orders passed by the honorable court.
Yes, Majumdar?
Yes. An appeal, my lord, can be admitted. Only one thing, my lord, what is wrong with the what he assails in the order of the learned single judge has not been pointed out. Where can what is he actually assailing in there?
No, I have
What is
stated-
wrong with the judgment?
Yes,
Some,
lordship.
some indication of that perhaps from.
What is wrong with the order?
I am just coming. Page 187, lordship, may kindly listen.
One?
Page 187. This was before the final judgment, lordship. 9/1/2019 is the order. After hearing this matter at some length, and after perusal of the records of the selection produced by Mr. Sri A. Deka, Land Standing Council of the Secondary Education Department, this court directs the Land Standing Council to obtain instruction as to the marks under a column of integrity and ACR have been allotted to the respective candidates. This direction is issued after considering the fact that from perusal of the records and the ACR in particular. So, lordship, the record was also perused by the learned single judge, and it is found that both the petitioner and the respondent number 6 were given the remark very good for the relevant 3 years in question and appears to be at par. Further, there is no adverse remark with regard to subpara 1 and 2 under the said column of integrity, namely earlier penalty and pending departmental proceeding. List this case again on so and so to obtain the aforesaid instruction. Thereafter, there was another order at page 191. At so and so, as per the last order dated 9/1/2019, the department was to furnish instruction regarding the marks granted in certain heads. When the matter is taken up today, Sri N. Sharma, Land Standing Council, prays for some more time to obtain instruction. Lordship, when the record was perused by this honorable court, Lordship had found from the records that both of us have given the remark very good. And there is no any adverse remark, but in the integrity and ACR column, Lordship, I was given 1 mark less, which deprived me from appointment as a regular principal. Although, Lordship, I am the senior most and I have better credentials than the respondent number 6. This aspect of this matter, Lordship, was not considered by the learned single judge while the final judgment was passed. And this judgment will also influence the pending writ petition, Lordship, which is still pending, where I have made a specific challenge to the B.Ed degree obtained by the respondent number 6. That is WBC 1733 of 2020. So my prayer before your Lordship is to issue notice at this stage and stay the impugned judgment and order, Lordship.
What is there to stay?
Even if your
What
Lordship
is there
stay,
to stay?
otherwise, Lordship, the writ petition 1733 of 2023, the judgment will influence this thing which is pending, the pending matter, Lordship. Because
How will it influence?
because this issue has not
How
been.
will it learn a single judge has clearly said that he is not commenting on the B.Ed degree as it was not challenged. Yes, was not.
And Lordship,
Have you read the last
Yes.
3 lines?
Yes, Lord.
Then what more is there to stay?
Even if your Lordship grants the stay because the respondent number 6 is working, that will not prejudice her, Lordship. Respondent number 6 is, is already
number
working,
6 is already working.
working as a principal. Lord. So even if your Lordship stays the order, that will not influence.
No,
Since it does not influence anything, my lord, the stay would not be necessary.
no stay is required to. But Mr. S.K.
Thus,
Learned counsel for the appellants.
Lordship, I just
We'll admit it then. Admit.
The respondent number 5, Lordship, she did not appear before the learned single judge. So, Lordship, since she has retired, notice may not be issued to respondent number 5. Because before the single judge also she did not appear.
Whatever it is, we'll have to issue notice. No, don't say admit. Issue notice.
Lordship may kindly admit it.
Ms. R. Magundal, then the standing council, school education. Department. I press for respondents 1, 2, 3, and 4. Is it SMDC? You can't.
SMDC I can, that is.
1, 2, and 3. Appellant to take steps for service of notice on respondents 4, 5, and 6 while registered procedure within 1 year. Please for the forward.
Item 12.
May I please, Lordship? My lord, this case relates to that, my lord, as per the advertisement, my lord, the first NIT in the minutes, my lord, my name was recommended. Subsequently, it has been cancelled, my lord, and some private respondent.
On last occasion, my lord has directed me to take the record.
That your lordship will see.
Online and offline mode submission of the documents, tender document. I have received the documents, my lord. Only difference, lordship, the writ appellant did not submit his land clearing certificate in the online mode, and the private respondent has submitted. I have flag mark, it is the yellow flag. Online submission, lordship. Lordship, the yellow flag is the only difference in the Fakhruddin Borghan's documents, lordship.
Lordship, the record was called for, my lord, just
Yellow
to
flag.
apprise, my lord. Page 71 and last page of my memo of appeal, my lord, same way we have submitted, both of us. And they are giving clean sheet, my lord, saying that it is the land revenue certificate. In my case, it is a only challan. That's why original record was called for.
Let us see that.
Yes, lordship, kindly have a look at page 71. Vernacular it is, and type copy is page 70.
No.
Lordship,
This is
kindly
not
have a
the
look.
case, my lord.
Page 70.
This is not the case, lordship.
Findings of the single are the same.
Lordship, can and last page, lordship, can see of the private respondent of memo of appeal, my lord. Page 195 and vernacular is 196. Same way, my lord. Both are challans, not separate certificate. That's why, my lord, lordship was pleased to call for the records.
Your one was page.
My one is, my lord, at page 71 is the vernacular. At 70 is the type copy. And private respondent number 5 is, my lord, 195 type copy and 196 is the vernacular. Same way, man.
Who's this Fakhruddin Barwe?
Is the
Is
private
the private
respondent.
respondent.
Lordship may I submit one thing. The case is that, lordship, in page 68, my lord will find the tender condition. Clause 25, my lord. Page 68 of the appeal memo, my lord. Page 68, lordship had got in, my lord.
Yes.
Clause 25, my lord. May I read, my lord? Tenderer must submit hard copies of his tender documents which are uploaded in the portal to the Office of the Executive Engineer IWT Division Silsar. However, tender will be finalized on the basis of the documents submitted on the online portal. Lordship may kindly have a look at the record. The writ appellant did not submit the yellow flag. This is submitted by the private respondent. Yellow flag 1, lordship, in the online portal. So we could not finalize the
challan.
Lordship. He did
He
not
is also
submit.
challan.
Challan, we are not disputing
He is
that,
also
but
challan,
he
me
is
also
not
challan.
submitting with the online
Yes.
portal, my lord.
So this is challan.
Lordship, this is
Where's
not
the-
submitted by the writ
The
appellant.
petitioner's document.
Petition the other one, Bachu Datta. Bachu Datta's documents, lord. He did not submit that documents through online portal, my lord.
However,
This is the case.
language is there, my lord. However, Hard copies are to be given.
No, however, tender will be finalized on the basis of the documents submitted on the online portal.
Hard copies of his tender which are uploaded of the portal so and so ITW. However, the tender will be finalized on the document submitted by the online portal.
Yes.
So
this is
now
the
Lordship
case.
will see, my lord, whether his document can be treated as a land clearance certificate and my case cannot be treated as a land clearance certificate. He is also no more. I am also no more. At the most, there should be a, my lord, fresh tender. At the most, my lord. Same way, my lord, same footing.
Maybe same, but since you have not submitted
My lord.
documents, how can it be?
Yes, my lord. To that effect, my lord, I realized the judgment of division bench of our High Court, my lord, where said, my lord, the lordship kindly permit me to have a look, my lord. It has been decided by our.
Are you
division-
admitting that?
No, my lord. So far, my document is concerned.
This has been submitted or?
No, my lord. So far, the document I have annexed, my lord. It reveals annexure 2, my lord. Page. No, my lord. I have not admitted. So now I will say. Lordship will see I have annexed document also. Annexure 2 of my writ petition.
At least the respondent submitted the challan. form.
He is also.
You have not submitted.
I have submitted, my lord. Lordship kindly have a look, my lord. Lordship kindly have a look at page 69. Page 69. These are the documents whichever I have submitted. Serial number 8.
This is hard copy.
Yes, my lord.
Hard copy. Yes,
Lordship.
But the online portal, in the online portal, you have not submitted.
Yes, my lord.
And the condition says.
Condition says I have to submit online as well as hard copy.
No. Tender documents will be considered only on the basis of documents uploaded online.
Online portal.
The two things.
My lord, but honorable single.
What says, that last paragraph it says that you will submit hard copy to the so and so.
My lord.
But your tender documents will be considered only on the basis of
hard
documents uploaded on the online.
Online.
So
now lordship
the
will see.
hard copy page 69.
My lord.
You have included 8.
My lord.
In the online.
My lord.
You have not put.
My lord. My lord will come, my lord. But so far the minutes did not cancel because of this, my lord. Minute is something else, my lord. Page 84, have a look, my lord. The second minutes. Without providing me, my lord, opportunity of hearing, how can it be changed? As per revised comparative statement submitted by the executive engineer so and so, it is found that the bidders have participated in tender process for the settlement so and so, that you will skip, my lord. Then lordship will see the decision. Tender committee reviewed the earlier decision and to accept the tender of the Fakhruddin and Khairul Barbuya rejected the Bachu Datto and Abdur Rahman recommends the name of so and so for Jatinga ferry for an amount of so and remaining period of financial. The proposal of the service will be sent to the government after receiving the favorable report of the land document of Fakhruddin Barbuya, my lord. Before coming to this, my lord, they have come to the conclusion. On that day, my lord, it was not, report has not come.
What is the requirement for report?
Report, my lord, I made a complaint that his land value is lesser than the tender value. Authority made a, my lord, inquiry through the deputy commissioner. That report has not come. Even me, my lord, in my case, they made a complaint. I did not submit all these documents. That report also did not come. Before coming to that, my lord, on 12th January 23, my lord, the second minutes was held But first minutes, my lord, have been shown as a clear document. Page 72. In the first minutes, my lord, page 72, it has been shown, my lord, I have submitted all the document as per NIT. And subsequent minute, my lord, without, I do not know anything, they came all these things. For which, my lord, the honorable court at the motion stage, my lord, has granted me interim order, my lord, that your lordship will see why it has been granted the interim order,
It
my
has
lord.
not been finalized yet, isn't it?
Yes, my lord.
Not yet. Final.
Lordship is per status quo order, lordship. It is ready, but in this pendency
No,
of
no,
this.
no. Read page 84. Decision.
Yes, not yet finalized. Tender committee reviewed his earlier decision and decides to accept.
Lordship asking.
I'm reading only.
Last 3 lines.
Lordship,
The proposal for settlement of the ferry service will be sent to the government after receiving favorable report
yes.
of land documents of Fakutin Barbuya.
At that time, we were not sent to the government, but after the
So
general.
you sent a report, you sent a complaint.
Yes, Lordship, with the deputy commissioner.
And then in the meantime, a revised comparative statement was sent by the executive
engineer, Lordship.
So you had a review of the tender committee.
Lordship.
Then whatever it is, tender committee said we are accepting so and so.
Yes, my lord. Because he did not submit it
But
to
that
online.
proposal
Lordship.
will be finalized only after you get a report from the
Deputy commissioner.
Got it.
My lord.
Have you received the report?
Yes, Lordship. We have annexed in one of my affidavit, Lordship. Lordship,
That
may
is
kindly
after
have a
review.
look. Page 302, my lord.
302?
302. Ito আমি পঠাইছো. Lordship, 303 in my copy, Lordship, the additional affidavit filed by the writ appellant. My lord.
It
But
is in the
additional
month of
affidavit.
February. It is in the month of February, my lord. In affidavit, lordship will see. Before report, my lord, it has been changed.
Lordship, page 303.
Lordship, kindly look the dates.
Whether his land value has covered both the bid or not, that was their complaint, my lord. And we have received report from the district development commissioner, Silcha, that his bid value is covered by his land value, my lord.
But report against me has not come yet, my lord.
It is not necessary because you did not submit your documents through online portal. This is the tender condition and tender authorities should abide by the tender conditions.
Your only problem is you did not submit your.
Yes, my lord, this is the case only.
But he also did not submit.
He submitted.
No, my lord, same way, Chalan.
How can you deny this document?
Yes.
No, both are Chalan, my lord, not the separate certificate.
This is a chalan.
He is also Chalan, I am also Chalan. But honorable single judge said that it is a certificate.
No, single.
Lordship, if I, my lord, chalan, 193.
In respect of respondent.
Let us assume that this chalan is a land review.
Chalan.
All right.
My lord.
He has submitted this chalan.
Chalan.
He has not submitted.
But even though my lord, terms condition says something else. Lordship, kindly have a look, page 68.
I've seen that.
No, my lord, land clearance certificate. Land clearance certificate,
Clearance certificate and what is challan?
altogether different things.
Council.
Altogether different things.
My lord, kindly have a look at the page, judgment page, my lord, 193, my lord. Lordship will clear from this thing, my lord. That was his not case before the single judge, my lord. In fairly, he submitted out of the three repetition. He did not plead this case that I did not submit this, my lord.
No, my lord, that is.
This
not-
193 page, my lord.
Yes.
193, my lord, lordship come to, my lord, from bottom, top, my lord, first, second, third, fourth, fifth, fourth line, my lord. After fourth line, my lord. For the petitioner, Batsu Datta, that the petitioner, Fakhruddin Barbhaiya had also deposited the challan from evidencing the deposited the land revenue at the time of the submission of the online bite, like the ones submitted by the petitioner. Batsu Datta, on inquiry made to Mr. Barbhaiya as to whether such plea has been taken in any of the three petitions preferred by the petitioner, Batsu Datta, he has fairly submitted that such plea has not been taken in
Because
any of the
I came to know only during the, only during the hearing of the case, my lord. I came to know about only during course of the hearing.
And so far, the my lord, reference of the my lord, the review committee, kindly have a look, my lord, at page. This was not case, my lord, to be decided by the review committee, my lord. Review committee on my basis of my complaint that he has not submitted the online application. That is why my revised statement was prepared. Kindly have a look, my lord, at page 165. Totally, my lord, he is misleading his submit, my lord, submission. This is kindly see, my lord. This is the reference, my lord, to the director. This was, my lord, content of the letter with reference to the subject and letter reference cited above. I have honor to inform you that the tender committee of this office has again scrutinized the tender document of the Jatinga and Rajnagar ferry services as per the complaint submitted by Mr. Fakhruddin Barbhaiya. That is me, my lord. And after that, my lord, this my lord, assessment was made, and kindly turn to page, my lord. This is 167. 167. This is column, my lord. The last line, Batsu Datta, where it lordship will get the from first, second, third, fourth, fifth, sixth, my lord, column, where the my lord, no, not submitted, my lord. It is head is that land revenue clearance. So this is not there. That is why that was referred to the my lord, review committee meeting. On the day of this, my lord, the revised statement, his complaint did not turn up, my lord. His complaint came after the revised committee, revised statement. And at the time of the review committee meeting, his complaint was not before the review committee. So this is, my lord, kindly see, have a look, my lord, 170 page. Minute.
Page 66
My
for
lord,
will be seen, my lord.
Let me complete.
What
Let me
document?
complete. Let me complete. My lord, kindly have a look at page 170, my lord. The heading that
Yes.
the heading is the minute of the tender committee meeting held on 12/1/2023 in the office of the Chambers of Director, Inland Water Transport, Assam, Ulubari, Guwahati, such and such. A review meeting of the department tender committee was held in the office of the Chamber of the Director, Inland Water Transport Department, along with the member for review of the earlier, my lord, decision in Jatinga ferry service. Here, lordship will get, as per the revised committee statement submitted by the executive engineer, Inland Water Transport Department, it is found that 4 bidders have participated in the tender process for settlement of the Jatinga ferry service for the financial year 2020-24. All the bidders have deposited their required amount of the earnest money along with the tender. The estimated value of the ferry services. Then, my lord, the Batsu Datta come, my lord, failed to submit the my lord, revenue clearance certificate.
That we have paid.
Yes, that is of the same thing happened to Rajnagar also. So on the day of the review committee meeting, his complaint was not there, and that was not finalized till this report has did not come before the the authority that the whatever complaint against me he lost, that was found valid, my lord. There is no such type of allegation was made, whatever is there.
My
So
lord,
my lord valuation was more than the my total value, 100 rupees more. And the findings of the Lord, my lord, single judge also that my value is more than the my total tender value. So there is no any my lord illegality, my lord.
However, the same is different like the notation.
Amar.
Next week we'll take up with.
But there never be same.
To be 13.
My lord, interim order passed earlier to be continued.
No, my lord, the interim order because only 4 months is left.
We'll discuss it on 13.
My lord, interim to be continued till then.
13 of this month, my lord. Oh my lord, pass on.
Lordship, interim to be continued. Interim continue this.
Item 13.
Please, your lordship. Here, my lord, in this appeal, we have challenged the impugned final order dated 26/6/2023, my lord. That is at page 64, my lord.
Yes.
May I read, my lord? By filing this writ petition under Article 226 of the Constitution of India, the petitioner is seeking a direction upon the respondent authorities for making payment of a sum of rupees 9,96,384 only as area enhancement rent for the period 1/5/2020 to 31/12/2022. In brief, the case of the petitioner is that by agreement dated 1/5/2017, he had let out his ground floor plus one-storied RCC building to the Pollution Control Board Assam initially for a period of 3 years at the provisional rent of 38,000 per month, which was to be assessed and fixed by the Assam PWD Building Division 1. After the expiry of the agreed term, the Pollution Control Board did not enter into a fresh tenancy agreement with the petitioner. Therefore, the petitioner had requested the Pollution Control Board from Assam for enhancement of the rent as per assessment made by the Assam PWD. The representations to the Pollution Control Board Assam for enhancing of the rent did not yield any result. However, the Pollution Control Board Assam vacated the tenanted premises on 31/12/2022 without paying the area enhancement rent from 1/5/2020 to 31/12/2022. Hence this writ petition. I am reading the relevant portion, the last paragraph, my lord, which we have challenged, my lord. 10th line from bottom, I'm reading, my lord. It is under such circumstances that this court is inclined to invoke extraordinary writ jurisdiction in the matter to direct the respondent number 2 to 6 jointly and severally to make payment of a sum of rupees 23,000 per month for the ground floor and 25,000 per month fixed for the first floor from 1/5/22 to 31/12/22 in terms of the letter dated 1/8/2022 issued by the Member Secretary, Pollution Control Board. My lord, this amount has been fixed on the basis of the offer made by the Pollution Control Board, my lord, which we have, my lord, we did not agree, my lord. Your lordship may kindly turn to page 41, annexure F, my lord. As per the agreement, my lord, the assessment has to be done by the, my lord, appropriate authority, my lord. And they will assess, they were supposed to assess and fix the rent, my lord. This is a assessment of house rent of the office premises, Regional Office Pollution Control Board, Gulf Press Road, Bamuni Moidan. That is page 41, I'm reading, my lord. With reference to your letter dated so and so as per the Regional Office Pollution Control Board, Guwahati, while letter dated so and so addressed to you. In this connection, the detailed valuation report for the ground floor and first floor have been submitted by AEEPW Dispute Territorial Building Subdivision Guwahati for the said building. The land valuation of the said building has been received from Additional Deputy Commissioner Kamrup Metro by letter dated 14/2/22. Accordingly, the rent of the building is calculated floor-wise as per Assam Urban Areas Rent Control Act 1972. The rent calculation sheet is enclosed here. Your Lordship may kindly see the my lord, valuation made, the rent fixed by the authority at page 42 and 43, my lord. 42 is rupees 30,508. Ground floor and first floor is next page, my lord, 38,629. This is the amount of rent fixed by the appropriate authority, my lord. But my lord, the amount which has been which had been reflected in the order of the Honorable Single Judge is the amount offered by the respondent authorities, which we did not agree, my lord. That is, my lord, rupees 23,000 and 25,000. And the appropriate authorities fix the rate as 38,000 and 30,000, my lord. So we have challenged this, my lord.
So you are agreeable, to 30,000 and 30.
Yes, my lord. That is fixed by the appropriate authority, my lord.
PWD.
Yes, my lord.
Lordship, I am appearing for PWD respondent number 7. The main contesting party is the pollution control board. We only
Any standing counsel?
yes, Lordship.
Standing counsel were there, my lord. My lord, I think.
We finished copy.
Yes, my lord. He was there, my lord. I think he has left.
You are appealing for the PWD.
PWD. We made the assessment, Lordship.
What is the procedure in Assam for making such assessments? It is the PWD who is the concerned
With
authority.
regard to the government accommodation or Lordship, the PWD normally does.
PWD normally does, even the assessment of the rent.
Yes, Lordship, if requested.
Okay. Then on what basis did the learned single judge came to the conclusion of this rupees 23,000 and
My lord, that is at
On-
page annexure K, my lord, page 49. This assessment was done by the Pollution Control Board themselves, my lord. And they have offered this, which we did not accept, my lord.
yes. What's the standing council, pollution control?
Yeah, I take it up on Monday, Lordship, since Monday.
Monday will be difficult.
Today he was there, my lord. He left, I think he left just now.
Lordship, on Tuesday then.
Day after tomorrow,
Yes.
Wednesday. Heard MS.SP. Chaudhary, learned counsel for the petition, appellant. On request made on behalf of the standing council pollution control. Some list on 6th. Wait, let us finish these two matters. Admission matters will come.
Item 15.
Yes.
Lordship, appellant before your lordship challenging the order dated 1/9/2023. Lordship, finding of the honorable single judge at page 13, lordship kindly able. Page 13, right. Case of the petitioner is that he was working as lordship as battalion in the Assam Rifles. He was released from the service on the ground that he made an application for voluntary retirement. His contention is that lordship he never made any application for voluntary retirement. It was his case that some of the blank paper authority obtained his signature, and thereafter it was done behind his back. That is under the that was his main contention in the writ petition, lordship. Lanet single judge lordship finding at page 13, para 8.
My lord, those contentions are already rejected, my lord, by the court. Paragraph 13. In paragraph 10, my lord, is reading, my lord, page 14. Direction was to consider the representation. And my lord, I have instruction that
yes,
the representation is under consideration. We will pass a speaking order. That was the direction, my lord, paragraph 10. The learned single judge, my lord, directed to pass appropriate order in regard to the representation dated 18/6/19. That, my lord, I have instruction that is under consideration. Anytime final order will come. But if he is aggrieved by that, my lord, if he is aggrieved by that order, he can challenge it. That will always be.
Lordship, it was made in the year 2019 till date. It is pending even after passing of the order passed by the honorable court, lordship.
What he's saying is that it is under consideration. Appropriate orders will be passed through. So if
in the meantime,
any order is passed, you can challenge that order. It may be in your favor, it may be against you. If it is against you, you have the right to challenge it. There's no point of filing this appeal.
That may be closed.
Then you withdraw it. It's better. Mr. L. Majumdar and the counsel for the appeal press for withdrawal of this appeal. Mr. H. Gupta and CGC appeals for the respondents. The appeal is accordingly dismissed and withdrawn.
With a liberty, lordship, if fresh cause of action arises.
That is always there.
That is always with you.
Item 16.
May it please your lordship.
Yes.
Lordship, this is a writ petition also actually. On the last occasion, it was listed before the single bench. However, as per one High Court notification, also it has now come before a division bench. It was last listed on 11/8/23, lordship. Lordship, the private respondents have also appeared in the matter. Let them file affidavit, lordship.
The challenge in this case is the appointment of special public prosecutor for the POCSO court matters.
Barpeta district, lordship.
Possibly, lordship will have to issue notice once again if it has come under the rules before the division bench. Notice was issued earlier by Justice Suman Shyam, sitting singly.
It's on 11/8, lordship. Last order was passed.
Notice is already issued.
Issued otherwise.
By a single bench.
Taken steps.
Yes, lordship. Then the private respondents have appeared also, lordship.
Okay,
I mean, they have filed Wakalatnama, lordship.
I have filed a
Respondents?
Respondent number 7, lordship.
1 minute. 1 minute. 7. Who appears for the High Court? Well, I think HK Das was there.
Yes.
On the last date, Lordship Justice Unnikrishnan Nair was appearing. Probably this has been now.
You'd like to file your affidavit?
My lord.
But Mr.
DJ Kapil, Lordship.
DJ Kapil and the counsel for the petitioner. Stop. Mr. SK Das, learned counsel appears on behalf of the respondent number 7. Stop. Mr. D. Majumdar, correct? Learned additional advocate general. Appearing for the respondents.
1 to 3, man.
1, 2, and 3. Praise for
5 also, man. 1, 2, 3, and 5.
1, 2, 3, and 5. Praise for how much time?
A little bit 4 weeks, man.
Praise for 4 weeks time to file affidavit. Praise a lot. List up to 4 weeks.
Item 32 from supplementary list.
Just another one.
Please, Lord.
Yes.
The order, my lord, impugn, my lord. The interim order which was there was vacated, my lord. Here's a case where, my lord, there was a Panchayat, my lord, no confidence motion, my lord. Now, my lord, honorable single judge's order, lordship will find, my lord, at page 1, my lord, 35 it starts, my lord. And, my lord, 135, my lord. My lord, the honorable single judge, my lord, vacated the interim order by discussions in para 9 and 10, my lord, but ignoring the most important, one of the important points, my lord. That, my lord, we had raised is that he was not served the requisition notice, my lord, requisition notice and the requisition, my lord, as per section 15 of the Panchayat Act. And that's a mandatory provision, my lord. Now, my lord, that is a specific case, my lord. Lordship will find out pleading said, my lord, page 25, 26, my lord. Para 7, page 25, my lord. Para 7, my lord.
Page?
My lord, page 25, my lord.
Yes.
My lord, as per the, my lord, requirement, my lord, the notice of the, my lord, no, the resolution, my lord, requisition has to be, my lord, served on the president, my lord. The impugn notice.
Which para?
Para 7, my lord.
7.
Yes, sir. That in the impugn notice has been mentioned that the said notice was issued as per the requisition submitted under section 15(2) of the Act 1994. But neither any requisition notice was served on the petitioner, nor she was informed about such requisition notice at any point of time by any authority or for that matter any member of the Panchayat body before that is the respondent number 6 to 14. Then, my lord, in fact, my lord, in page 31, paragraph 10, my lord. Last but 5 lines, my lord. Page 31, para 10, my lord.
Yes.
Further, the impugn notice was issued neither serving any requisition to the petitioner, which also violates the provision of section 15 of the said act, as well as principle of natural justice, and unless the sound the court interferes in the matter, the petitioner will suffer irreparable loss and injury. My lord, the stay vacating petition that was filed, my lord, there is no averment, my lord, contradicting, my lord, that statement, my lord, that it was served on me, my lord. Now, my lord, lordship will find under the Panchayat Act, my lord.
Where's the Panchayat Act?
Section 15, my lord. Every president or vice president shall be deemed to have vacated his office forthwith. And resolution. My lord, page 28, my lord, section 15.
Yes.
Every president or vice president shall be deemed to have vacated his office forthwith when a resolution expressing want of confidence is passed by 2/3 majority of the total number of members of the Gaon Panchayat. Such a meeting shall be specially convened by the secretary of the Gaon Panchayat with approval of the president of the Gaon Panchayat. Such meeting shall be presided over the president if the motion is against the vice president, and by the vice president if the motion is against the president. In such a case, a meeting is not convened if a meeting is not convened within a period of 15 days from the date of receipt of the notice, the secretary of the Gaon Panchayat shall within 3 days refer the matter to the president of the concerned Anchalik Panchayat, who shall convene the meeting within 7 days from the date of receipt of information from the secretary of the Gaon Panchayat and preside over such meeting. In case the president of the Anchalik Panchayat doesn't take any action within the above specified 7 days time, the concerned Gaon Panchayat secretary shall inform the matter of the deputy commissioner, subdivisional officer civil, as the case may be, within 3 days after the expiry of the stipulated period of 7 days time, and the concerned deputy commissioner, subdivisional officer shall convene the meeting within 7 days from the receipt of the date of receipt of the information with information to the Zilla Parishad and the Anchalik Parishad Panchayat and preside over such meeting, provided that the concerned deputy commissioner, subdivisional officer civil, as the case may be in the case of his inability to preside over the meeting, will depute one gazetted officer not under him, not below the rank of class 1 gazetted officer to preside over such meeting. Provided further that when no confidence motion is lost, no such motion shall be allowed in the next 6 months. 10 my lord, 2 my lord. The requisition for such special meeting under subsection 1 shall be signed by not less than 1/3 of the total members of the Gaon Panchayat and shall be delivered to the president or the vice president, as the case may be, of the concerned Gaon Panchayat with information to the deputy commissioner of the district. So it makes it mandatory, my lord, to serve the requisition, my lord. This is one of the grounds that I have taken, my lord, in the petition, my lord. Another ground was, my lord, that the deputy commissioner could not have, my lord, delegated his power to, my lord, convene the meeting to the to another officer, because here what happened, my lord, the CEO issued the notice, not the deputy commissioner, for meeting, my lord. And if he couldn't have convened the meeting, my lord, because the power couldn't have been delegated. What he could have delegated only is the power to preside over the meeting, my lord, to CEO or any other gazetted officer. That is the second point that I had raised, my lord. So therefore, the first point, my lord, this requisition, my lord, has to be given to me, my lord. And it's my specific case, my lord, this requisition has never served on me, my lord. That point has not at all been discussed or been considered, my lord. It's going to raise, my lord.
My lord, he has missed section 15(5) of the same act, which he has read. Just
No,
now.
look,
Section
15(5) will come
I would
later on,
like
my lord.
to draw your lord's attention to page 44 of this writ petition, his writ appeal. 44.
Yes.
My lord, initially what had happened, that a no confidence motion was moved by the ward members both against the president as well as the vice president of this Gaon Panchayat. He was the president and the another vice president was there. So page 44, my lord, it says, as per subsection 5 of section 15 of Assam Panchayat Act, and based on requisitions submitted by 1 + 7, 8 ward members had served a requisition notice both against the president as well as the vice president. I read out section 15(5), my lord.
Yes.
Section 15(5) states, if under subsection 1, the members of the Gaon Panchayat express want of confidence both in the president and vice president of the Gaon Panchayat at the same time and issue notices, the secretary of the Gaon Panchayat within 7 days from the date of receipt of such notices shall report the matter to the president of the concerned Anchalik Panchayat, who shall arrange to convene the meeting within 15 days from the date of receipt of the intimation, separately to consider the motion against the president first and to consider the motion against the vice president next day, and shall preside over both the meetings. The president of the concerned Anchalik Panchayat presiding the meeting shall have no vote. In case the president of the concerned Anchalik Panchayat does not take action as above, the secretary of the Gaon Panchayat within 3 days after the expiry of the stipulated 15 days time shall refer the matter to the concerned deputy commissioner or the subdivisional officer civil, as the case may be. On receipt of the information, the deputy commissioner or the subdivisional officer, as the case may be, shall convene both the meetings in the manner as above within 15 days from the date of receipt of the information, with intimation to the concerned Anchalik Panchayat and Zilla Parishad, and preside over such meetings, provided that the concerned deputy commissioner or the subdivisional officer, as the case may be, in case of his inability to preside over the meeting, may depute a gazetted officer not below the rank of class 1 gazetted officer to preside over such meeting. Provided further that if it is not possible to hold the meeting for a situation due to non-attendance of the requisite number of members in such meeting or meetings, as the case may be, the no confidence motion shall automatically stand cancelled and the motion shall be deemed to have lost. My lord, in this case, as per section 15.5, no notice needs to be served to the president. It has to be directly served to the secretary of the Gaon Panchayat, who will thereon follow the procedure as laid down under section 15.5. What had happened, my lord? I'll just take you a little back.
One minute. Yes.
So, my lord, as per at page 44, a BDO had moved a notice stating that on this particular stipulated date, the no confidence motion will be held. The first round of litigation took place, wherein the learned single judge held equivocally that BDO is not the competent authority to convene this particular no confidence meeting, and accordingly set aside that impugned notice. Page 51, my lord, that's the order of the learned single judge, the first round of litigation involving the present appellant.
Then
At page 51, the learned single judge had held that the impugned notice that was issued by the BDO ought to be set aside, but they had not set aside he had not set aside the requisition notice that was sent by 8 members. So that requisition notice still stands valid under 15.5. Subsequently, my lord, since the requisition notice stands valid and the learned single judge had held that liberty at page 51, he had held that liberty is granted to the respondents to take appropriate action in the matter by following the prescription of section 15 of the Assam Panchayat Act 1994, if so advised. So accordingly, my lord, now at page 93, I would like to draw your lord's attention to page 93. So now, as per the dictat of subsection 5 of section 15, 8 ward members, my lord. At page 95, you would see all the names of the ward members. All these ward members wrote a letter to the secretary on the 18th of August 2023, stating that in pursuance of the order that was passed by the learned single judge, we are filing this particular notice so that you can take appropriate action against the appellant herein. Page 94, para 5, my lord. Page 94, para 5. Therefore, as per the order dated 14/8/2023 passed by the Honorable High Court, that is the order passed by the Honorable Single Judge, Your Honor may graciously be pleased to take necessary steps to convene the special meeting to discuss the no confidence against the President and the Vice President as per section 15 of the Assam Panchayat Act 1994 to meet the ends of justice. So considering the fact that the learned single judge had not set aside the requisition notice, but had only set aside the the notice which was issued by the CEO, in pursuance thereof, the ward members continued from there on. So after writing the letter to the secretary, now what the secretary did is at page 96, my lord. At page 96, this secretary of the Gaon Panchayat wrote a letter to the president of the Anchalik Panchayat to convene this no confidence meeting as per section 15.5. Everything is going as per section 15.5, my lord. The president, however, of the Anchalik Panchayat did not convene this no confidence meeting. So thereafter, what they did is they moved the deputy commissioner. The secretary moved the deputy commissioner, which is at page 99. At page 99, the secretary moved the deputy commissioner that due to the inaction of the president of the Anchalik Panchayat, the special meeting could not be convened. So the deputy commissioner may do the needful. So as soon as the deputy commissioner received this particular letter, my lord, from the secretary, he authorized the CEO to intimate all the concerned stakeholders, which he is very much empowered to do, my lord, because in section 15.5, it clearly states, section 15.5 the second paragraph, my lord. In case the president of the concerned Anchalik Panchayat does not take action as above, the secretary of the Gaon Panchayat, within 3 days after the expiry of the stipulated 15 days time, shall refer the matter to the concerned deputy commissioner or the subdivisional officer civil as the case may be. In this case, he has intimated the DC. On receipt of the information, the deputy commissioner or the subdivisional officer, as the case may be, shall convene both the meetings in the manner as above within 15 days from the date of receipt of the information, with intimation to the concerned Anchalik Panchayat and Zilla Parishad, and preside over such meetings. So this particular statute has empowered the DC to intimate all the concerned stakeholders. Now, one of the objections that has been raised by the appellant is that how can the CEO intimate the concerned stakeholders? He's not empowered under section 15(5).
That's a different matter. That's a subject matter of the writ court.
No, what has happened, Malad?
No, there is another
The
section.
issue here is, Malad, my learned friend is totally Malad misplaced the site.
Anyway, there's
provision.
no time. We'll take it up on the witness.
Malad, there's some urgency, Malad, but taken.
List the matter again. List the matter. List this matter on 6th.